has not been recorded in the order sheet now for correction.
For correction.
Yes, sir. I request for the
No, no. Yes.
I have an urgent matter, my lord. I have been selected as LPG Distributorship 2 years back. Then offer letter has been issued. Appointment letter has also been issued. All on a sudden, last Friday, I have been intimated that in my place, another person has been selected.
Okay.
I have made him party. Let it appear on Wednesday top. I shall serve all.
Okay. Leave granted.
Wednesday.
My lord, may be permitted to mention one thing, my lord. This is the matter of year 2017. My lord, hearing was made for some times, my lord. All the parties were served.
Group 1 matter.
Group 1 matter, my lord.
So
My lord,
what you
fact
want?
is this, my lord. Unfortunately, I came to learn that the matter has gone to my lord Lok Adalat. So order sheet does not detect anything, my lord. So my lord,
How it was sent to Lok Adalat?
that is our question also. So it may
Your
kindly.
advocate on record must
Yes, yes, I am
prayer for
advocate on record.
must have there in a
So I
prayer for
went to the chair, my lord, department. They asked me to mention, my lord. Kindly.
so what happened there in the Lok Adalat?
My lord, nothing. We were not
Why
called at all.
Okay.
We were not called at all. My lord, my client is there, my lord. We are suffering. And kindly, my lord, take it under the hearing to be mentioned, my lord. Everything will
It would appear Thursday. Thursday and Friday I am taking up only group 1 matters.
Yes, my lord.
Okay, it will appear Thursday to be mentioned.
Thursday to be mentioned. High level list on my lord.
Group 8 matter.
Group 8 matter inclusion.
Inclusion.
Okay. You know,
Your Lordship, may I permit to grant leave? Extremely urgent matter, Your Lordship. The urgency is that 3 tender has been floated by the IOCL, Indian Oil Corporation Limited. One tender, which is in Paradip terminal, that has been terminated and blacklisted only in respect of the Paradip terminal. But another incident is that the truck, not tank truck which is running, loading and unloading the LPG cylinders of the IOCL without any intimation, without any show cause notice, without any hearing, that has been stopped. No order has been passed. Even the transportation bill has not been disbursed on and from January 2025.
what you want in the writ petition?
I am praying for to reply and load and unload
The
the.
company has been blacklisted. That's why.
That is in respect of Paradip terminal, and the company has in the email dated 30th of May 2025 that has been clarified. We have
No,
continued
whether blacklisting in respect of Paradip
only
terminal
Paradip, only Paradip
is there
terminal.
such order?
Yes, yes, that
And in respect of other terminal, you are okay.
yes, and circular says that if the blacklisting has been done in respect of one terminal, but the running tender which is
The
floated by
running
the
tender which has been running
that-
in the other
that
terminals,
has
that would be
which has been
continued.
awarded, that will be continued. Circular has been annexed.
Okay, okay.
Grateful, man. I want to move Wednesday to 10:30.
Wednesday,
Grateful.
Wednesday, leave granted. Yes,
My lord,
Yes,
may I be
Paul.
permitted to mention, my lord, item number 102 of today's list, my lord. Well, let it
100?
appear 102 of today's list.
what is this? Today also you are having a resolution.
No, my lord, not yet. I have not yet received any. Well, that has been uplifted.
That has been?
My,
Okay, okay, okay. Item number
Well, item number 102,
102,
102.
new motion matter.
Yes, my lord, let the matter appear tomorrow, my lord, as mentioned matter, my lord. Preferably at the top,
102,
my
I
lord.
will take it, I will taking this today.
My lord, your lordship. Your lordship will be taking up mentioned matters today.
No, new motion
New
matter.
motion matters today.
Yes.
So let the matter appear as mentioned matter tomorrow, my lord.
You are not ready today.
Today, my lord, I am ready. I am ready, my lord.
Let's see if he's not reached today. Okay,
Well,
If
this
it
is
is not
102, my lord, 102,
102, I know.
102.
Let's see, if not today, then tomorrow mention matter.
Tomorrow at the top, my lord.
Not top. There are only
And then, my
several
lord,
top
this
matters.
is with regard to compassionate appointment of a lady, my lord.
I understand, but there are several matters in the mention matter. No, not more matters. Only 10 to 20 matters. It will be taken up. If not today, tomorrow. Okay, call the list.
My lord, I have mentioned item number 114 of today's list, my lord. This I have mentioned earlier in the earlier week, my lord. This is the first time contempt matter, my lord, wherein your lordship has passed a specific direction.
114 not contempt matter. This is
144, my lord.
144 contempt matter.
Contempt matter, my lord. This is the first time contempt matter. I mentioned it before your lordship on the last week, my lord.
Okay, contempt matter. 1, 2, 3, 4. 4 contempt matters. Wednesday first. First Wednesday contempt matter দেবেন. First দেবেন. ঠিক আছে?
Great.
First contempt matter.
My lord, may I be permitted to mention, my lord?
Yes.
This matter was listed, as per your lordship direction, this matter was listed on Friday at 12:30 for reply. My lord, today this matter has not appeared. My lord,
Today,
matter has not appeared before your lordship.
which matter?
My lord, that 2nd April hearing,
Yes, it was reply fixed on 12:30.
that was on Friday.
So Friday you are not appearing.
My lord, Friday,
Yes, there is a resolution. It will again appear on Friday. Next Friday.
Friday.
This is the list. The list will be running like that because of the fact that group 1 and group 8 matter I am taking. So the list will running on that basis.
I'm obliged.
My lord, maybe for mention on matter, my lord will remember that my lord order was that last occasion it was mentioned the file was missing. My lord was placed person order on 8/8/2025, fixing the 19th 8 to be appeared before the lordship. 19th appeared, but my lord, that amount, that matter now today's list appearing 148. Previously supposed to appear on 19, but anyway it could not be taken up. 20, next date 5th, 13 or 14, so far my knowledge concern, my lord. Remember, so far I remember.
What you want? What is the item number?
It will taken up.
Item number
Item 148 of today's list, my lord.
to be mentioned matter.
My lord, this should be this was early this one. My lord's order passed. My lord, can I see the order? My lord's order.
What can I do? It would be mentioned matter first matter 148. To be mentioned matter first matter. কালকে তো মেনশন ম্যাটার দেবেন কালকে তো মেনশন ম্যাটার ফার্স্ট দেবেন কালকে কোথাও ওয়েডনেসডে বললাম কালকে তো মেনশন ম্যাটার দেবেন তারপর টু মেনশন ম্যাটার দেবেন ঠিক আছে I will taken up first mention matter some 15 to 20 matters thereafter your matter will taken up to be mentioned matter will taken up
Tomorrow, my lord. Tomorrow.
Tomorrow it will be listed as to be mentioned matter. It will taken up second list. Okay.
Second list.
Second item.
Second.
First mention matter, thereafter to be mentioned matter. Yes, call the list.
My lord, item.
Group 1 or group 8? Group 8 matters. Whether it is listed or not.
No, it's not listed.
Application.
Yes. My lord, I've served.
Have you served?
Notice is at.
Call the list.
There is one 10:30 matter, my lord.
My lord, item number 1 and 2 is the extension of interim order. Lordship, the interim order expired on 22nd of August. If your lordship kindly consider the last order passed by your lordship.
Which for the state? Mr. Dey.
Mr. Dey, my lord, we have served.
This matter appear under the heading of extension of interim order. Full stop. It appears that the interim order passed by this court on the earlier occasion was extended till 22nd of August 2022. Learned counsel for the petitioner submits that the pleadings has already been completed, so necessary order may be passed for extension of interim order. It appears that the matter was fixed for hearing in the combined monthly list of July 2025. However, the hearing was not taken up. Concerning the same, the interim order passed by this court be further extended till
After Puja vacation, my lord.
till 21st of November 2025 or until further, whichever is earlier. This is the matter for hearing on 6th of November 2025.
My lord, if your lordship kindly fix any time, my lord,
No time.
as your lordship is.
Next.
I am for this petitioner on last
For the
occasion.
respondent number 8, my lord, last occasion,
Last occasion, my lord was pleased to direct me to serve the supplementary affidavit to the advocate appearing on behalf of the private respondent. I have already served. Today is the date fixed for the state to file the report in the form of affidavit.
for last two occasions, state has not appeared, my lord. Now the difficulty is, my lord, if I do not get the report filed by the state, my lord, then it will be difficult for me to file my exception or the opposition against the
Let
supplementary.
Mr. Arjun Roy Mukherjee, have you served? Mr. Arjun Roy
Yes,
Mukherjee.
yes, he has already appeared on first two occasion. He has appeared.
State is supposed to file affidavit.
But,
Not ready.
Put in the form of affidavit.
my lord, what happened that they have served him, the petitioner, but they have not filed it before your lordship.
They have not?
They have not filed before your lordship.
Okay, okay. You have received the copy of affidavit?
I have not, my lord.
You have also received?
No, no, no.
You have not received. Learned counsel for the petitioner submits that he has already received a report in the form of affidavit affirmed by the state. Record speaks, no such report in the form of affidavit was placed on record. Full stop. None appears on behalf of the state respondent. Concerning the same, petitioner is directed to serve the state, intimating the fact that the matter shall appear in the list on September 2 under the same heading. Parties are directed to liberty to exchange their affidavit in the meantime.
My lord, only one thing, my lord.
Yes.
My lord, my client resides in Malda, my lord. But
So
what I am apprising, my lord, if I get the copy of the state the report, a copy of the report filed by the state, then I shall be able to file all the exceptions together, my lord. That's what.
Can you say able to? They will file a report against the writ petition, not your.
No, that's what I'm saying, my lord. Even the state will file a report. If I have to take an exception or a rejoinder, whatever it is.
Then you come on, right? Come on 1st of September. I will give accommodative.
First,
1st of September.
my lord, let it be on third, my lord. Fine.
Let it be on.
Let it be on second, my lord. First, I have some-
Let it be on second, my lord. Let state
Second.
appear on that day. Thereafter,
Okay,
whatever.
second.
I'm getting.
Next.
I'm sorry. Petitioner, my lord, my tenure is just on the week, so I'm taking a short pass.
Pass it over.
Obligement.
Next. Call the matter. Chot takun. Takun.
18, my lord, 18, I'm for the petitioner, my lord. Item 18, my lord, there are similar two matters, my lord, which are fixed after the vacation.
Similar matter fixed after
After
vacation.
vacation on 10th of November, my lord.
10th of November. Which
Yes, my lord.
matter?
My lord, item number 40 and 41 of my lord last week's list, my lord, it has been fixed.
What
my
is the
lord.
item? What is the number?
Case numbers, my lord.
You are for the petitioner here,
Here, my lord.
and there you are.
Petitioners only.
Okay.
The report has been filed by the state in this matter, but in those two matters, they are not filed, my lord. So, my lord, kindly.
What you want?
My lord,
Fix the matter on
fix the
10th.
matter on the 10th, my lord.
On the prayer of the learned counsel for the petitioner, let the matter appear in the list on 10th of November 2025. Along with writ petition number?
My lord, I'm giving the numbers, my lord, to the
Okay.
court officers.
Next.
Before other matter, my matter, I will not say the top 10:30 maybe. Appear 10:30. Otherwise,
Huh?
I mentioned in the morning. Leave matter.
12:30 তে কিছু আছে দিয়ে দিন 12:30 count 12:30
Yes.
12:30
I have taken.
to 12:30
12:30 12:30
it will appear on 12:30 12:30
Sure.
next next
Your Lordship, I am for the private respondent.
24 who is for the petitioner
Excuse me. I am for the private respondent.
22 call করবেন Orpita Kundu for petitioner. You are for the private respondent.
Yes, my lord. Respondent number 6. I am raising the maintainability of the said writ petition, your lordship.
Mr. Arjun Roy Mukherjee for the state. First call, none appears on behalf of the petitioner. First call. লেখুন এখন.
Great.
Next.
My lord, I am for the opposite party number 6, my lord.
None appear on behalf of the petitioner. First call. Next.
I am for the private respondent.
First call. Next.
I am for the petition.
Yes, Mr. Shah.
There is a direction for filing a report.
Let's see where is the report.
But the copy of the report has been served upon me.
You received the copy. Twenty-seven. 27. Mr. Timir Boron Saha, learned counsel appearing on behalf of the petitioner. Mr. Timir Boron Saha, learned counsel appearing on behalf of the petitioner, submits that he has already received a copy of report in the form of affidavit filed by the state. However, no such report be placed on record by the state authority. None appears on behalf of the
My
state.
lord, Miss Sinha is appearing for the state
You
respondent.
are appearing for the state. Okay.
Miss Sinha, my lord.
Miss Sinha represents the state on
আমি
behalf,
আছি।
represents the state respondent.
আর কে আছে?
Considering the situation, let the matter appear in the list on 1st of September.
Grateful,
Another
my
same
lord.
heading, 1st of September.
Grateful, my lord.
Next,
I am for the state lordship 28.
you are for the?
State.
Who is for the petitioner? First call. Next. Next.
But 33, 34, and 37. Your lords kindly place the matter next week, since it's Monday week. Since similar issue is pending before your lordship, and your lordship is hearing the matter, the age bar of 45 years matter.
45 is also.
Monday means 1st of September.
Monday week.
Monday week.
33, 34.
Let the matter appear in the list on 8th of September. 8th of September.
Including 35 also, lordship. Similar issues are.
34,
34
33,
same.
34, 35 and 37.
I am for the petitioner, lordship. And 37.
And 37.
35.
33, 34, 35 and 37.
My lord.
Okay.
8th of September.
8th of September. Next.
35
36. Call 36. Next. হয়ে গেছে। Call the list, call the list.
I am for the petitioner, my lord. 39.
Yes.
But I have served copy upon all. Service has been affected.
Yes.
The
what is
matter
the
related to fair price of ration shop.
Yes.
The license has been granted in favor of the ration number 13, whose ration shop, the godown, which is the main criteria, that is illegal and unauthorized construction without permission. He constructed without permission from the authority. And I have my godown is with permission and with the sanction plan of the Pradhan. My lord, only I am very innocuous fair, page 48. I made representation. And let them consider at first, my lord. Page 48. And take decision in presence of after giving opportunity of hearing all the parties.
So what is the status of your candidature? Rejected.
No, not selected. The selected.
What is the status of your candidature? Rejected.
No.
Then
But the point, according to point, the
there must have a portal regarding your result.
Yes, my lord.
Where is the result?
Result they have not published.
So whether they have selected
They selected one person. They selected respondent number 13.
License issued.
Yes, my lord.
Where is the copy of license? Have you got it?
Page 47.
Page 47 is the license.
License. Page 46 starting. Page 47. Page 46. And his godown is with unauthorized. Where the godown is situated.
License is May 2025. Why are you appearing today?
But I have filed. Kindly have a look to.
When you filed it? July.
July.
Then
12 July 2025.
So your result has not been intimated to you. What is the result?
Now only they page 43. They passed a rigid order, but without considering my.
They passed a rigid order.
Rigid order. Page 43.
Why they passed the rigid order?
Page 43.
43.
Only they have considered this is not work property, but they have not considered my page 44, my lord. My written submission. I have stated that this godown is on the which is unauthorized construction without permission, without any sanction plan from the Pradhan, which is main criteria. The godown that should be authorized.
No. Why are you saying? Your representation has already been considered.
No, kindly have a look to. They have considered only this, whether this is work property or not. But main criteria, the godown is unauthorized and illegal.
No, you look the order, page 43.
43.
Page 43. They have referred your letter dated 23rd of April 2025. This is your representation dated.
Yes, my lord. After passing this order, my lord, I came to know subsequently that this godown is unauthorized and without sanction plan.
You have to place a fresh representation. Where is the fresh representation?
Page 48.
Page 48 dated 23rd of April. Not fresh.
My lord.
You read the date of your application.
23rd April.
Yes.
April 2025.
Yes. That was considered.
No, that has not been considered.
Oh. That is the only representation they have considered. Issue afresh. Having heard the learned counsel for the petition.
May I submit, my lord, one thing? This region order is not good. This is not in accordance with the provision that they have not considered. They have not stated that this godown is unauthorized or not. Whether they can issue license in favor of the person whose godown is unauthorized and illegal. That has not been stated.
So how you can demonstrate that the godown is illegal? Is there any document?
Yes, my lord.
Where is the document?
One case has been filed before this court for demolition of that construction. That WP number 11861 2020. That is
2000. What is the number?
1100 800 11861 2025.
2025. So it is whether it is listed.
That is pending sub judice.
Before whom, before which matter?
Before the, before court number 42.
Show me something in support of your contention that the go down is illegal or unauthorized constructed. Where is the document? Is there any document?
No document, but I
Then-
made representation and the matter is pending sub
Your
judice.
representation was considered, it was turned down, you have challenged that representation, now you are saying otherwise.
No, this representation has been considered, but without considering the matter that this matter is the go down is unauthorized or authorized. That has not been considered. And regarding that matter, one case has been filed for demolition of that structure and which is pending sub judice. Let them submit report, my lord, whether this go down with permission of the Pradhan or not. Let the Pradhan submit report, my lord. If the Pradhan submit report, that may be decided. Pradhan has been added as a party in this matter. The Pradhan is the appropriate authority regarding sanction plan.
Look,
So
you have
the-
submitted a representation on 23rd of April 2025, wherein you have challenged that the go down was constructed over the walk-up land.
Walk-up plan.
Walk-up land.
Walk-up plan.
So it was considered,
And
it was-
twofold here.
no,
That is walk-up plan.
there is nothing. There is nothing in your representation that it was unauthorizedly done. Read it. Only walk-up board has not considered. That is the only issue.
My lord, kindly see, my lord. Page 44. Page 44. I constructed building, third line from the fourth line. I constructed building for go down with permission of Pradhan.
What is this?
This
44?
is written submission before the authority.
When you file this, no date, nothing is there.
But at the time of hearing, my lord, I submitted. At the
What is
time
the
of hearing.
date? How can you submit this on the date of hearing? Where is the
And I have
copy?
stated that has not been considered. The second part, the main part, he constructed, his construction is illegal and unauthorized. That has not been constructed. My lord, the Pradhan may be submitted report, my lord. Whether if the Pradhan submit report that is not illegal, then I have no case. Pradhan has been added as a party in this matter. And Pradhan is the appropriate authority to say that whether this building is illegal and authorized.
No, look, you have not taken the same issue before the authority. Now you are taking a new
No,
issue.
my lord, page 44, I submitted my written submission.
But it was not mentioned in your representation. You have not mentioned it in your representation.
Subsequently, I came to know after submitting my representation.
Then you have to submit a fresh representation. You submit a fresh representation and come. They shall deal with your representation.
The Pradhan may be directed to submit report whether this matter.
No,
this
no, no,
building is
not
illegal
like
or
that. You cannot make out a case like that. You don't have any document, nothing, evidence is there regarding illegal construction or nothing.
Matter is pending sub judice. Let this matter dispose of, my lord.
Then you, after disposal, you can come. Let it be pending. Let the matter go out of the list. You mention it after disposal of that matter. Otherwise, how can I entertain?
But only if your lordship directed the Pradhan, my lord, to submit report.
How can I? Only on your pleading, on your affidavit? No. You must have something, some materials. Otherwise, I shall not entertain. Either I can keep it pending.
But regarding illegal construction, the Pradhan is the appropriate authority.
Look, you
Let the
cannot
Pradhan
make
submit-
out a case right now. You cannot make out a case. I shall not allow you to make out a case without any affidavit, without any document. How can I allow you? You have not also made this point before the authority. Now you are challenging the authority's order by making a new case. How can I? You subsequently may have known that. Then you have to make a separate representation to the authority. Let them decide the issue.
But what may I submit before your lordship? Liberty may be given to submit a representation and only direction will be given.
Very
So
good.
if I make representation, they may be considered.
Very good. I am disposing of the writ petition, granting you liberty to make a detailed representation to the authority.
And if I made representation, they may consider it.
They will consider it automatically.
Yes.
Please take down. Having heard the learned counsel for the petitioner, it appears to me that the petitioner has not made a representation to the authority in respect of the grievances as demonstrated before this court. Considering the same, the instant writ petition is disposed of with a direction to the petitioner to make a representation to the authority within 2 weeks from the date of passing of this order. On such representation, the concerned authority shall dispose of the representation within 8 weeks from the date of receiving such representation, after giving a reasonable opportunity of being heard to the petitioner. I make it clear that the instant the concerned respondent authority shall dispose of the representation according to law without being influenced by any observation of this court. Since no affidavit has been exchanged between the parties, allegation made in the writ presentation, allegation made in the instant writ petition shall be deemed to have been not admitted.
I'm good.
Disposed of. Next.
In item 40, Lordship, it's similar to the others matters, Lordship, that is called as item number 34 and 35, Lordship. Let it be listed on 8th of September, Lordship.
Let the matter appear in the list on 8th of September 2025.
Grateful to your Lordship.
Next.
Kindly take up next week.
Not this week. Next.
In 42, Parshvati Dev is out of station. His petitioner is out of station. Kindly adjourn for 2 days, ma'am.
I am for the private response.
Next week, Monday. Not this week.
44, 45.
Next.
43, Lordship. I pay for the petitioner, my Lord. May I pay the affidavit of service, my Lord?
Yes.
42.
42.
Private response. Private, who is for the petitioner?
I am for the state, my lord.
Make it not this week.
Who is for the petitioner? Petitioner is not there.
No.
Lordship has.
Mr. Huda, you are there for the petitioner, I think.
There's confusion, my Lord.
They are opposite parties.
No, Mr. Shahar is saying item number 42 has been called. I am in 43.
No, item of 42, not this week, I say.
Not this.
বলছি তো হয়ে গেছে হয়ে গেছে
Item of 43.
43.
Yes.
Item 43, my Lord, IPF for the petitioner, my Lord. The petitioner, and my Lord, made an application for being appointed as an FPS dealer, my Lord, in terms of a notification which is dated 4th of January 2022 at page 15. The fact that, my Lord, I had applied for this my Lord, vacancy would appear from page 18, which is my application, my Lord. Application ID, my Lord, 0218. These are undisputed facts, my Lord. However, my Lord, my application was rejected, which would appear from page 19. Screenshot, my Lord, of the online portal, my Lord, page 19. Therefore, my Lord, after this rejection, my Lord, I issue a representation which is at page 20. And I say, my Lord, that there is no reason, my Lord, for my rejection because I possess all the required criteria in terms of the vacancy notice and the control order, my Lord. Now, this, my Lord, is replied to by the state, which your Lordship will find at page 30.
Okay.
Page 30. Response regarding the rejection of application for license of Najima Bibi
your letter dated so and so, which is my representation. In response to your letter dated so and so, this is to inform that Najima Bibi mentioned to be your client has applied for online application. Well, it directly comes to paragraph 2. It was found on field inquiry that Muhammad Mahasin Ali Khan, the father-in-law of Najima Bibi, the applicant, is presently holding an FPS license at village so and so, so and so. This is true, my lord. My father-in-law, of course, my lord, I have a strange relationship. I do not stay with my father-in-law. We are separate, my lord. But it is true. My husband's father is a dealer. And thereby, Najima Bibi, your client, is a relative of an existing FPS dealer. As per para 13 of the FPS vacancy notification bearing number so and so, Najima Bibi is not eligible. A copy of the concerned portion of West Bengal so and so, the Act, as amended, is enclosed herewith for your ready reference towards clarification of the definition of relative as per so and so. So, the only reason why my application is rejected is because my father-in-law is an FPS dealer, and according to them, he falls under the definition of relative.
Yes.
Now, Lordship will kindly come to, and they have, my lord, disclosed the relevant notification, which is at page 31.
Yes.
And my lord, what they are referring to, your lordship will find at page 34, part 3.
Yes.
13. 13.1 says a person holding a license of FPS dealer or distributor in his name or person whose relative, as per clause 2XA of the West Bengal PDS MMNC order, already has a FPS dealer, distributor of or wholesale license. So the only reason why I'm rejected, my lord, is because my my father-in-law is a dealer. Now, lordship kindly, my lord, takes the definition once. First, my lord, we start with 2X.
Yes.
Relative. Relative includes family members and the following kin. Son or daughter, not important. Daughter's spouse, son or daughter. Brother other than the brother of bachelor, his spouse, son or daughter. Sister other than sister, so and so. And my lord, it also includes the definition of family member. So if your lordship sees, my lord, the definition of family member is at K. Spouse, parents, son, daughter, son's spouse. So perhaps this is what they're referring to. Son's spouse. My lord, but if your lordship goes, my lord, strictly in terms of the definition, Lord, had it been father-in-law, my lord, father of spouse, then my lord, I was out. Lordship has got it. But it is not father's, spouse's father, but it is spouse's son, son's spouse. So strictly speaking, my lord, I do not fall in any of the categories. And it does not, the definition does not say vice versa. Till date, my lord, the definition does not say vice versa.
Family member
Yes.
is at M.
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 No. We are looking at 2024 control order, my lord. K. Or even if your lordship goes by, my lord, what they have supplied, even then. Because perhaps they are depending on the, my lord, the definition in 2013 controller, and they are correct. So even if going by this definition, because it has not changed, going by this definition, my lord, family member M means lordship will come to page 32. Spouse, parents, son, widow, daughter. then the definition of relative would include son's spouse, son or daughter. Parent's brother, spouse's brother or sister. But this does not include, my lord, spouse's father. And in my case, my lord, had spouse's father been mentioned in the definition, my lord, I was out of court. But at first, branch, my lord, even I was, my lord, I had said, no, you don't have a case, my lord. But then when I went through the definition, my lord, said, no, there definitely is a case, my lord. State.
Son's spouse.
Yes.
Son,
But at
daughter.
first brush, my lord, it would seem that I'm disqualified. That's correct. But going strictly by the definition, my lord, the definition does not include my father-in-law. Had spouse's father been included, my lord, as I said, I was out of court. Perhaps they got confused because of, my lord, XA1, son's spouse. Or rather, let's put it like this. Had my father-in-law applied, had my father-in-law been an applicant, my lord, then he would not have received the license, had I been a dealer.
Who is appearing for the state? None appears.
File the affidavit of service, my lord.
You appear in this matter?
But I'm told, my lord, we've served twice. Now, my lord, it has been the state's consistent stand, my lord. In cases of compassionate appointment, my lord, they, my lord, oppose tooth and nail, my lord, when it comes to definition, because they say, no, this is not included in the definition, so we will not allow this. Now the state cannot take a contrary stand and say, no, it would mean vice versa, until unless it's there in the order.
Very good. Yes, I understand.
Lord, I will be relying, my lord, on this is an unreported judgment, my lord, WPA 5352 of 2022, my lord. As usual was there. But paragraph 5, similar, I'll hand over the copy, my lord. It is an admitted position that the petitioner.
What is the status?
Status, my lord, they have only, my lord, published the vacancy notice, my lord. That also I have.
New vacancy notice published?
No, not note. This is the old one. Sorry. This is the one that they had annexed.
So what is the status? No one is appointed. Okay.
As it is.
Miss Sinha, you appear in this matter.
Yes.
But she was giving me a tough opponent.
Okay. Affidavit of service filed on behalf of the petitioner be taken on record. Inspired service, none appears. Miss Sinha, who usually appears, learned AGP, who usually appears state respondent in this matter, is hereby appointed to represent the state in this matter. Let the appointment of Mr. Sinha be regularized by the concerned. Next matter.
Lordship, it should be Mrs. Sinha.
Okay, Mrs. Sinha. Mrs. Sinha.
With a junior of her choice.
With a junior of her choice. With a junior person. Okay.
Mr. Huda will be assisting me in this case.
The brief matter of the instant writ petition is that the petitioner's candidature for fair price of dealer has been turned down by the state with an order dated 4th of June 2025 containing inter alia that father-in-law of the petitioner holding an FPS license, thus she comes under the definition of relative of an existing FPS dealer. Full stop. Mr. Huda submits that according to the provisions of clause 2M of Control Order 2013, petitioner neither being a family member or a relative of erstwhile MR dealer of existing MR dealer, namely Muhammad Mahsin Ali Khan. Full stop. That be the situation. He challenged the impugn order dated 4th of June 2025. C challenge করতে হবে. C challenge. And prayed for necessary mandamus be issued against the respondent authority to give her FPS license. Considering the situation, the state shall submit a short report. Submit a short report within 2 weeks. Only point of law. Only point of law.
1 week is enough for this.
I'm fine.
Okay. Submit a short report within 2 weeks from date. Let the matter appear in the list on.
Copy may be served, your lordship.
Yes. On 9th of September.
Not required, but it's
9th of September. Petitioner is directed to serve the copy along with the annexures thereof to Mrs. Sinha.
the only thing, my lord, since your lordship was dictating, I did not disturb, my lord. The only thing is, my lord, this order of 4th June 2025, my lord, this reply, it's just a response to the representation, not an order. This is just clarifying why I was rejected.
Okay, কি বললাম বলো, not order, response to the representation.
Yes, response to the reply.
ওই যে order dated করা ছিল না? Response to the representation dated.
Yes.
4th of June 2025.
By this, they have just said why was I rejected. My rejection is already there.
Okay, 9th.
That was kept it on 9th.
9th. Under the same heading.
Obliged, deeply obliged.
Next.
This is otherwise an interesting matter, my lord.
I am for the statement. I am for the private respondent.
Who is for the petitioner? What is the matter?
It's a private dispute.
It is private dispute.
Absolutely private dispute. Apart from that, my lord, that it is a prayer for consideration of representation relating to issuance of fresh license incorporating the name of the heirs and successor of the one of the partner. And its license has already been issued. During the pendency of the author, I have come with the license, my lord. License has already been issued.
You are one of the partner.
I am one of the partner. My husband was the partner. After the demise of my husband, my lord, myself and my 2 sons were incorporated as a partner. And accordingly, fresh order of the license has already been issued.
Very well. I am disposing of. None appears.
Yes.
None appears on behalf of the petitioner on call. State as well as the private respondents are represented through their learned counsels. Considering the entire circumstances, the incident deed petition is disposed of. Disposed of as dismissed for default.
Okay.
Next.
Dismiss for default.
This is for
Lordship, it is a item number 16, passover matter. So my instruction is there to kindly make it not today in this matter, Lordship. I beg your pardon, Lordship.
What?
16, passover matter,
Why
Lordship.
they pass it over?
Yes. My senior asked me
Not
to
this week, not this week.
oblige, my lord.
Next.
In item 45, Lordship, I led by Mr. Sobosai Chatterjee in this matter, Lordship. I am paying for not this week, Lordship.
Not
Because,
this week?
yes, your Lordship.
Very well.
Sara is for the private
Not this week.
Grateful to you.
Next.
46 আমাদের vacancy.
46,
47.
47 is the vacancy 2024. Your Lordship has adjourned
46 and 47.
Your Lordship, kindly, 8th of September, Your Lordship fixed other part.
Both matter. Let the matter appear in the list on 8th of September 2025 under the same heading. Both 46 and 47. Next.
49.
My lord, in item number 48, I beg to appear for the petitioner. My lord, there are certain documents which we have procured after filing of the writ petition. The main of those things are, my lord, we preferred an RTI. Reply has come just last week. I want to prepare a supplementary affidavit and file on the next
Leave
occasion.
is granted to the petitioner. Leave is granted to the petitioner to file a supplementary affidavit in support to the writ petition. Let the matter appear in the list on 10th of September 2025 under the same heading. Next.
Madam,
Obliged.
But petitioner applied for my lord fair price of dealership. But without any reason, my lord, his candidature has been rejected. And my lord, he came to know that private respondent's name has been approved. And a lady, unmarried lady, her mother is a member of Jila Parishad, my lord. That is
only your issue.
Yes, my lord.
So
without any reason, my lord, my candidature is based.
Have you made any representation?
No, my lord.
Then you have to. Otherwise, how can this court be approached?
My lord, if my lord, they will clear that how my candidature has been rejected.
Then you made a representation. Why before this court?
Then my lord, kindly
Right to sue afresh. Having heard the land now.
This writ petition has been considered as a representation kind.
No. Writ petition cannot be. How such status be such? Okay.
But in the meantime, if her name has been.
You made a representation. Otherwise, I cannot understand how you appearing before this court without representation. Now, having heard the learned counsel for the petitioner, let the instant writ petition be disposed of with a liberty to sue afresh on the same cause of action. Next.
My lord, in this matter, my lord, may I humbly pray for a not today, my lord.
Item number 50.
Zero, my lord.
Not today or not this week?
Whatever, my lord. Not today will do, my lord.
Not today only. Very well, not today.
My lord.
My lord, 51, my lord, I appear on behalf of the petitioner, my lord. My lord, I appear for the respondent oil company, my lord. My lord, perhaps the writ petition has become infructuous. No, my lord, I was apprehending this kind of a submission from my learned senior, my lord. My lord, if your lordship...
What is the matter?
My lord, the matter pertains to appointment of a third-party dealer in place of another dealership, which is under a partnership, my lord. Now, there are interstate dispute between the partnership. There is an arbitration which is pending consideration before the arbitral tribunal. My lord, may I just indicate, kindly bear with me for some time, if your lordship be pleased to come to the cause title of the writ petition for once, my lord. My lord, the petitioners, my lord, are the two partners, and thereafter, my lord, respondent number 8 and 9 are also the partners. The partnership is at serial number 10. Billimoria Brothers. Have your lordship has found that?
Okay.
No, Billimoria Brothers is enjoying a dealership from time eternity, my lord. It's a
so 1, 2, 8 and 9 are the
partners of under respondent number 10.
Very good.
Thereafter, my lord, respondent number 11, Hiral R. Gandhi. She happens to be the proprietor of another dealership under the same oil marketing company, BPCL, and carrying on business under the name of VTF Fuels. Now, my lord, Hiral R. Gandhi happens to be the wife of Ronak Gandhi and daughter-in-law of the respondent number 8, Mahendra Gandhi. Now, my lord, I'll directly take your lordship to the representation. Your lordship will find that at page number 81 at the fag end of the writ petition, my lord. The last annexures, forming part of the last annexures. if I'm allowed to place, I, Tushar Gandhi and brother Gautam Gandhi are partners of Bilimoria Brothers, a dealership registered with VPCL under such and such. Well, the first grievance was unauthorized induction of Ronak Gandhi. Ronak Gandhi happens to be a partner under the partnership firm respondent number 11. But prior to induction of Ronak Gandhi, there were 4 partners. There's another person who is respondent number 13, against whom I do not have any allegation. He happens to be the partner of the partnership firm in the year 2014, subsequently resigned in the year 2019. 2014, upon induction of Ronak Gandhi, the partnership was consisted of 5 partners. 2019, Chandrakant Gandhi, another partner, stood retired with effect from 2019. So there is a reconstitution which is going on 2014 and thereafter 2019. As your lordship is very much aware, there is a reconstitution guidelines under which there is a directive upon all the dealership that prior to you give effect to such reconstitution, prior permission and consent has to be taken from the authority concerned. Now that has not been done. I, being one of the partners, I am equally liable. But the situation over here is that Mahendra Gandhi was always at the helm of the affair. My lord, kindly appreciate this is a family business. Mahendra Gandhi happens to be the eldest son of the family. After a change of generations, Mahendra Gandhi happens to be being the senior most person of that particular generation, was at the helm of the affairs of the partnership firm. Now the partnership firm is carrying 2 different kind of business. One is the dealership under the BPCL. The second one is there is a liquor business under the BEVCO. 2014, when Ronak was inducted, and subsequently 2019, when Chandrakant stood retired, the partnership was carrying with 4 partners. 2019 onwards, the 2 petitioners and the 2 private respondents being 8 and 9, as I shown your lordship.
Yes.
Now, my lord, in the year 2023, the dealership was lastly reconstituted. Your lordship will find that at page number 55 of the writ petition. Have your lordship?
Page number 55.
55. Lord, over a non-judicial stamp paper of 100 rupees.
January 2023.
12th of January 2023.
This is
Kindly
the-
see, my lord, the heading over there, DSPL agreement within inverted comma A. My lord, the site where this dealership is running, my lord, it originally belongs to the Indian Railways.
Indian
Railways, my lord. It's adjacent to the Kharagpur railway station. Now, the land was leased out in favor of the partnership at a point in time, and subsequent thereto, in furtherance of the right accrued under the lease, the land was further subleased in favor of the oil company, and in furtherance thereof, this agreement has been treated as a site. I'll indicate why I'm indicating. Then the very next page, at the middle end portion, on the left-hand column, started with to be filled in case of a firm, insert name of all the partners. Kindly mark the name of the partners, my lord. Page 56, the very next page. Mahendra Gandhi, Tushar Gandhi, Chandrakant Gandhi, and Gautam Gandhi. So 2023, the dealership which has been executed by the partnership firm along with the oil company, it has been acknowledged that there are 4 partners. The name of Ronak Gandhi was appearing nowhere. Now, my lord, if I'm allowed to take your lordship to the partnership agreement itself. My lord, that will appear from page 23 of the writ petitions. The lordship has found it. The amended deed of partnership is made on 1st day of April 2019. My lord, kindly see the partners between Mahendra Gandhi. Second is Ronak Gandhi. My lord, on the next page, there is Tushar Gandhi and Gautam Gandhi. And my lord, on the very next page, page number 25, Chandrakant Gandhi, the fifth part. Matlab, on page number 25, the fourth paragraph, the party to the fifth part has expressed his desire to retire from the firm with immediate effect due to his preoccupancy with other businesses and has agreed to his share of profit shall be distributed to all the remaining partners. The revised profit sharing ratio, thereafter the revised profit sharing ratio has been reflected in the next page at page 26.
You are reading page 25.
25, my lord, the fourth paragraph, starting with the line, the party to the fifth part.
Okay.
If your lordship corroborate with the first paragraph itself, which define the fifth part, that is Chandrakant Gandhi. Now, Chandrakant Gandhi should retire in furtherance of deed reconstituted deed with effect from 1st of April 2019. And my lord, the effect of his retirement will further be reflected from page number 26, on the serial number 3, profit and losses of the business. Your lordship will find there are 4 names in which this 100% profit of the partnership will be further divulged into. So, my lord, it's an admitted position that the partnership is running with 4 partners since 2019. However, as I shown your lordship already, 2023, when the dealership agreement is getting executed, the dealership acknowledges 4 partners. One of them is Chandrakant Gandhi, who stood retired in 2019. However, Ronak Gandhi, who has been inducted over here, has not been acknowledged as a partner by BPCL. Now, my lord, the dispute started between the partners in the year 2021. The arbitral proceeding has been initiated at the behest of the private respondent in the...
No. In page 55 and 56,
lordship.
55 to be filled by the case of the... That is Mahendra Tushar Chandrakant is there and Gautam.
Chandrakant Gandhi and Gautam Gandhi.
Yes.
So Chandrakant stood retired in 2019 in furtherance of page 25 and 26, which I have shown.
So why you entered the agreement with the
My lord,
23?
that is where I'm coming, my lord. That is where I'm joining issue.
Lord, may I cut short the matter, madam?
No, what is the grievance against the
My lord,
authority?
the grievance, my lord, the first fold of grievance is that I have sought for a termination of the dealership. The partnership is on the verge of dissolution. The arbitral proceeding is going on. My lord, valuation report has already come out. Now, in the amidst of all these things, this particular thing, I never had the knowledge. I never had the occasion, and I'll show from your lordship where from I have obtained the knowledge. I have obtained the knowledge during pendency of the arbitral proceeding in an application under section 17, whereby the respondents has come up with this dealership agreement. As I indicated, lordship, I was a kind of person, I was naive. I was only looking after the sales.
So there are dispute between the partners.
There are dispute
and
between the
you
partners.
made a representation to the authority to cancel the
dealership. That is one, my lord.
They have not cancelled it.
My lord, not yet. My lord, they have issued a show cause. That is my first fold of grievance. They have issued a show cause that is pending consideration. Now,
Then they have issued a show cause.
my lord, the second part is
Reply has been received. Date of hearing is there.
My lord, I am not aware of, my lord. I have
Then
my,
may not be aware.
my lord, my instruction from my client is
Okay, exactly, my lord.
Mandamus is asking for termination of the contract between HPC.
No, it was dealing with by the authority whether it would be terminated or not.
My lord,
it is not
repetition, but that is the first thing I mentioned, my lord, at the beginning.
My
It's
lord,
an
so far as the
infractuous
second,
repetition.
so far as
Court's
the
time is
second
wasted.
dealership is concerned, my lord, kindly bear me for a
Second
moment. Your
dealership
lordship
is not
given me a patient hearing so
subject
far.
matter of this writ petition, my lord. Unnecessary court's time is being wasted, my lord. Valuable time.
Authority walking
They have
in.
taken steps.
My lord, the
on the
authority,
basis
my
of
lord,
your-
it's an unfortunate part, my lord, when an authority cannot submit that something has been worked in derogation of the
You have
guidelines.
made a representation. Authority have taken note of.
My lord, a
They-
part
they
of the representation. My lord, kindly take my representation. There are two different allegations.
Whatever may be the allegation, let they deal with this.
My lord, they have not dealt with only so far as the partnership is concerned. So far as the appointment of the proprietorship is concerned, they have not entered into. Kindly there be a direction that similarly that steps should be taken, and in the
Let them decide any issue altogether.
This is the show cause notice. We have received reply. Now hearing will take place and decision will be taken.
Let
What
them
is
take
left
an
in this
action.
writ petition, my lord?
My lord, kindly ask them to give a copy of the show cause notice, because so far as I am the complainant, my lord.
Approach them.
You are
They
who?
will
You are
serve
who?
a copy.
Tushar Gandhi.
Tushar Gandhi.
Yeah, it has been addressed.
No, VTR fuels. Kindly see.
Yes,
that.
it has been addressed to his
No,
Okay,
kindly.
it has not.
My lord, kindly.
Now it is an infractuous. Let them take a decision. Thereafter, you
My
come.
lord, I'm only asking, my lord, I'm only thinking that so far as this show cause notice is concerned, to my limited knowledge, that is only respect of the partnership firm. But so far as the appointment, appointment of the ad hoc dealership under the name.
They must hear you. They will hear you. They have
My
started
lord,
the
in the
proceeding.
meantime, my lord, what is happening, kindly appreciate from the partnership, from the compound of the partnership, the third party has been allowed to carry on business, and where the profit is going into the pocket of the same partners because it belongs to the family members of the partners
To raise
itself.
objection to the
It is the essential commodity. Supply cannot be stopped
Raise the
because of the
objection
internal
at
fight.
the time of hearing.
Yes.
He is insisting on the prayer B, then Lord, it's a private dispute, out and out a private dispute.
Absolutely.
This can't be adjudicated in a writ petition.
Okay, okay.
I need to Lord, file an affidavit if your lordship.
No, I will dispose of this matter.
My lord, kindly don't dispose
direct
it of,
the
my
oil
lord.
company. No,
My lord,
kindly
kindly
direct the
don't
oil company
dispose
to
of,
take
my lord.
steps, my lord, in accordance with law, my lord.
And the time-bound manner, my lord.
Whatever order, this is the show cause notice.
Copy them.
And we are kindly write to them if they are.
Based on my representation, show cause has been issued. Now my learned senior is asking to write to them for asking a copy of the show cause.
Why have you not refused? My instruction is yes, you have refused to accept the show
So
cause.
he cannot just submit
Not
blatantly
here.
that I have refused, my lord.
You take steps.
Well, the show kindly appreciate show cause has been issued at my behest on my complaints. Now he's saying I have to write to get a copy of the show
We have
cause once
received
again.
reply to show cause notice from other addresses also. My lord,
But
this,
at least
this
I should
shows,
get
my
a
lord,
chance to
this
rely on the
bona fide.
purported show cause, my lord. I should get a chance to rely on this purported
And
show
my
cause.
learned senior friend, Mr.
Obviously, you are the petitioner. You are the complainant. You
My lord,
must
I
be
am the
heard.
complainant. That's what I'm submitting, my lord. I have never
Lordship
been
will
favored with a
direct-
copy of the
You have a copy.
My lord,
Lordship
kindly
will
see the
direct
content of that thing.
show cause notice, if not served on all the parties, will be served. Opportunity to reply to them given, and it come to a legal conclusion, my lord, within a reasonable time.
Well, within a time-bound manner, my lord.
Okay, I'll pass out. No, where is your representation?
My lord, my representation is at, my lord, page number 8080, starting from 81, my lord, to be precise.
My lord has a copy of the show cause I have handed over.
I have a copy.
My lord, kindly, my lord, page number 81, kindly once consider clause 3, my lord, pointer 3, my lord, conflict of interest, breach of one family, one dealership, my lord. My lord, so far as the part, as I appraise your lordship, that there are two different distinct entities. One is the partnership firm where my clients are the partners, and the other one is a proprietorship
I
firm.
understand. Let them deal with your objections.
My lord,
everything.
my lord, that is the only direction I am seeking, my lord. That comprehensive direction may be given for consideration of both the complaint. My
They
lord.
have already taken up.
My lord,
Already taken up.
my lord, I am not been favored with a copy. If my
Yes,
learned friend can give a
I'm passing down.
Lordship will direct them.
Okay, okay.
Sir, एक बार देखते भाई कॉपी.
You'll get it. Let the order be passed. You'll get it. So far as the first partnership deed and the arbitration proceeding is concerned, the oil company is not a party. Those are absolutely
not even entering into that.
Yes. So those has
There's
really
no
no
privity
bearing in the
between the oil
petition.
company and the
Absolutely a
petition as well.
private dispute, my lord.
So your representation dated 1st of April. 1st of April.
1st of April, my lord.
2025. Yes.
76. 5th June. 2nd June.
2nd June, my lord.
And then the 4th June representation.
76. 2nd June.
Yes.
2nd June and 4th June.
4th June, my lord.
Please take down. Petitioner is aggrieved against the conduct of the respondent authorities regarding allowing business in favor of respondent number 10 and 11. Respondent number 10 and 11.
Respondent number 10.
Your objection is against respondent 10 and 11.
10 and 11, my lord.
10 and 11. It is the contention of the petitioner that there is a dispute between the partners.
The partnership has respondent number 10, my lord.
He's asking for cancellation of the dealership, which is subsisting in favor of the partnership. Respondent number
10.
That is it.
That is the main grievance.
10.
কি বলেছি বলো? না তার আগে বলো।
My lord, not if
Is
your lord,
aggrieved against the conduct of the respondent authority for allowing business in favor of respondent number 10. No, respondent number 10.
my lord, as well as 11, my lord, my prayer A is specific on that point. Terminating
10 and 11.
10 and 11, my lord.
10 and 11. Take it, 10 and 11. Full stop.
But 11
Is the private person.
is a private party. There can't be, my lord, a termination of 11. My lord, we are not recognizing him.
My lord, it's only my submission that is going down, my lord.
No,
My lord,
no, just wait. I shall not pass any order like that.
my lord, then
Otherwise-
it has to be
otherwise
heard,
you
my
will
lord.
Deal otherwise, I understand. Very well. No. Allowing business in the name of Messrs. Bilimoria Brothers. Within bracket, respondent number 10. It is the contention of the petitioner that the petitioners and respondent number 8 and 9 are the partners of respondent number 10. Full stop. The petitioner made detailed representation with the authority on 2nd of June 2025 and 4th of June 2025 regarding unauthorized induction of Messrs. Ronak Gandhi. Full stop. It is the further contention of the petitioner that an arbitration proceeding is going on between the partners regarding their dispute in the said partnership. Full stop. The authority concerned, without considering the entire dispute, allowed the business to run in the name of respondent number 10. Learned counsel appearing on behalf of the oil marketing company submits that on the basis of the representations of the petitioner, the authority concerned has already taken steps, so cause has already been issued on 10th of July 2025. Learned counsel for the oil marketing company further submits that reply to the so cause has already been filed by respondent number 8 and 9. Full stop. Learned counsel for the petitioner submits that he is unaware about the said so cause.
My lord, we have received a reply of the show cause from the writ petitioner number 1 as well, Tushar Gandhi. This is the.
You have also received.
Yes. My lord, he's saying he has not received the show cause.
My lord, my lord, things have been twisted, my lord. With deepest of respect, kindly appreciate my lord. My representation is a comprehensive representation, considering, my lord. Now he is saying he cannot act upon. My lord, being an outsider, my lord, forget, my lord, whether this respondent number 10 is a part.
He has given reply, and the hearing will not.
My lord, kindly appraise the content of the show cause, the concern, the contention regarding the respondent.
Whatever maybe you have already replied.
My lord, kindly appreciate if I have replied on that. My lord, if I have replied on that thing, my lord, that is only.
So are you denying this?
No, my lord, I'm not denying that. My lord, if I would have, since I have already acknowledged and give a reply. So far as respondent number 10 is concerned, kindly appreciate what is the content of the show cause. That is in respect of Billy Moria brothers. But what about my complaint in respect of the respondent number 11? That
Let them deal with your all.
that has not even been acknowledged, my lord. My lord, he is my lord, kindly record his submission, my lord. My lord, BPCL is not even recognizing my complaint regarding the respondent number 11. Kindly
let them decide the issue.
My lord, they are saying, my lord, on record they are saying.
No, not like that. Okay. I understand. They have not taken a decision. কি বললাম বলো? না ওটা এক জায়গায় করবে যেখানে করেছি রেসপন্ডেন্ট নাম্বার 8 and 9 বলেছিল রেসপন্ডেন্ট না একটু আগে পড়েছি বলো ওই তো জাস্ট আগের লাইনটা পড়েছি বল as well as respondent number 1 full stop হয়েছে learned counsel for the petitioner submits that the oil marketing company while issuing the show cause has not dealt with all the objections and point of representation filed by them to the authority concerned full stop. Learned counsel appearing on behalf of respondent number 8 and 9 submits that the instant writ petition is infractuous. The issue has not been decided yet by the oil marketing companies. Thus, the instant writ petition is liable to be dismissed. Full stop. Having heard the learned counsel for the parties, the oil marketing companies is directed to serve the copy of show cause upon the learned counsel for the petitioner within 7 weeks, within 1 week from date. Full stop. It further appears that the oil marketing company has already taken note of the objections and representation of the petitioner, on the basis of which they issued a show cause. However, the show cause, at the option of the petitioner is not dealing with all the representations and points thereof. Thus, the petitioner has at liberty to demonstrate all his grievances during the hearing to be given by the petitioner, to be given by the oil marketing company, to all the petitioners and the respondents, all the parties concerned therein. I make it clear that as the respondent authority has already initiated a process to determine the issue, thus this court refrained itself from passing any comment in respect of the merit of this matter. So when the date was fixed for?
My lord, hearing date is yet to be fixed.
Okay. So within 6 weeks?
My lord, one person has not replied, others have replied.
So within
we
6
are
weeks?
Giving a reminder and we'll take up the hearing, my lord.
Okay.
My lord, kindly
We
fix
have
a
sent a
timeline.
reminder to the non-answering party. So after a reasonable time, a date will be fixed and everyone will be intimated.
Okay, very good. কি বললাম বলো? From passing any comment in respect of the merit of this matter. Any comment in respect of the merit of this matter. Full stop. Under the above assumption, the instant writ petition is disposed of with a direction to the oil marketing company to serve the show cause notice upon the
Lordship, it has been served and reply has been received.
Okay, sir,
my lord,
petitioner number 2.
Yes,
my lord,
yes,
petition.
Tushar Gandhi has signed. I have given a copy.
No, two has not, I think.
1 and 2 are joined, my lord. If one has
joined.
received, my lord, if one has received, my lord,
Individual cannot be treated as a joint, my lord.
both are joined writ petitioner.
Yes, right. 100-year-old wants to be dissolved. This is their main object.
And both of them have filed a combined writ petition also as 1 and 2.
Okay.
My lord, since my other portions of the complaint has not
Lordship,
been
kindly
acknowledged,
see
that is my limited
this
submission,
document.
my lord.
Before your lordship, this document, it has been signed by him.
My lord, my limited submission is
The
regarding non-consideration of my part of my prayers, my lord. If that liberty may be granted on a timeline.
I have given you the liberty to demonstrate the matter at the time of hearing.
Yes.
I have given you the
Lordship will not
liberty.
give them any further direction to serve show cause. It has been served and reply given.
Okay. কি বললাম বলো? Read petition is disposed of. Company to not cut off, to intimate the replying parties to submit a reply within a specific period of 2 weeks. Within a specific period of 2 weeks from date, and thereafter the oil marketing companies shall arrange a date for hearing of the matter in presence of all parties concerned within 3 weeks from the date of receiving of the reply.
Puja vacation will intervene. So some more time, because if there is an order of termination, it has to be approved by the highest authority also. So
no, give them hearing.
Merely the hearing authority will not pass the termination order unless approved by the higher authority.
No, you have
It's
to
some time. And
4 weeks.
as pointed out, it's a 100-year running firm.
Okay,
Well, how my learned senior is bothered about a private firm?
Okay.
Possibly, my lord, possibly
Okay, I
my learned
understand.
senior has forgotten that he's
I do my
representing the,
business through him.
he's representing a authority, my lord.
My lord, I am doing my business to him. And
Okay,
this
roll
essential commodity, I am certainly bothered. We'll give a reasonable time, my
Reply.
lord. They will not
So,
delay
okay,
things.
hold on. The decision of the authority shall be intimated to the to all concerned
By 15th November.
by
October is the
20
Puja
by
holiday month.
20th November 2020.
Lordship.
By 20th November 2020.
Lordship.
Under the above observation, the writ petition is disposed of.
Grateful.
The
May I
show
file my
cause and the reply be kept with the record.
Show cause notice issued by the Bharat Petroleum Corporation Limited dated 10th of July 2025 and the reply
by the writ
filed by the writ petitioners on 22nd of July 2025 be taken on record.
My lord, along with my affidavit of service, my lord.
Affidavit of service filed on behalf of the petitioner be taken on record.
Grateful.
Okay, fine. File it. The private respondent number 8 and 9 is at liberty to file their power within the day, within this day, in the course of this day.
My lord, extremely grateful.
Okay. Thank you. Next.
My lord,
I am for the state, my lord. I am led by Mr. Dot.
I am praying for short passover, my lord. Mr. Council petition.
Passover.
My lord.
Passover. Not Passover. Okay, pass it over now. Just wait. Next.
My lord, I am led by
For the state, your lordship.
my lord. I am led by Mr. Somiran Mondal. Kindly make it not this week, my lord.
Not
Or
this week.
Or after vacation, my lord.
Or after vacation.
My lord, there is a
Let it
amicable
be go out of the list.
My lord,
Let it be.
kindly,
You
my lord,
mention it. Otherwise, after vacation, I do not know if it be
kindly
taken
make
up this list or not.
kindly
Okay.
make it not this week.
Now you are coming to not this week. You are not ready to do with this matter. Let it be very well not this week.
My lord.
Next.
Before my lord, on the advocate record on behalf of Mr. Sheikh Saifuddin, I am praying for not today.
Not today. Next.
Report দরকার ছিল।
Yes. I have you about the petitioner, my lord. This is one of those notification matters, my lord. Remember, there was a direction upon the state to file the report.
My lord,
আপনি যদি জানতে চান সেটা বলুন, কোর্টে জানিয়ে দেবো।
Yes, Mr. Sengupta, report ready.
Report is ready, but the problem is that I have requested the concerned authority to make it in an affidavit form. This has not been come up as an affidavit form of the affidavit. So your lordship kindly takes it up, but the problem is that otherwise it will be difficult because it is addressed to my name.
Tomorrow I have fixed several matters on that. On the
11th lordship has fixed the several matter of the curtailment of the benefit of the
11
beneficiary.
কালকে
26th.
হ্যাঁ তো আর what I do is that মিলট এটা কোথাকার scanning
South 24 পরগনা।
what I do is that Milord, I have prepared all the Milord the notes. Now I will be arguing on this basis. If possible, Milord, I will prepare the affidavit and place it before your lordship by tomorrow.
By tomorrow?
I will try because the person concerned is scanning from coming from the canning. That is the whole difficulty. Otherwise, I could have been done it.
But there are some other matters also, my lord, where the state is yet to file their report.
Let
In
it
around-
appear tomorrow. Let it appear tomorrow as Mr. Sengupta is arguing. He would be ready tomorrow.
But I will, Lord, I also need to file the exception.
All the matter you know the merit and you are also
I have no issues with that.
submitted
I
the
have no
reply
issues.
on several matters.
I have only point I will be arguing today, tomorrow, is that whether the fundamental right can be considered, whether the 19(1)(g) has been attracted by way of
Chaudhary is there
notification or not.
The other petitioners also.
Sorry, Milord?
Mr. Chaudhary is there for the other
There
petitioners.
are other petitioners also there, Milord.
That's why I fix the matter. all
I
matter.
understand, Milord. I appreciate, Milord. I fully appreciate.
Let
Milord.
it fix on tomorrow.
So I believe, my lord, tomorrow the matter would be taken up in that.
Yes.
Fairly, in that event,
If you have other merits to demonstrate, accept the matter.
beneficial settlement.
Only point of
This, my lord, I'm sure, my lord, this is also, my lord, the issue is same, my lord.
issue is same.
Issue is same, but in this particular
Are you
report,
ready tomorrow for argue this matter?
this particular
Yes.
matter, Milord,
Not this particular matter, several matters are there.
several matters, I am almost ready. If your lordship kindly, would you?
Mrs. Sinha is there, you are there.
Yes. I will be.
Tatto is also there in some matter.
Most of the matter I will be leading. I will be taking the point of maintainability and will show to your lordship that these are the judgment lordship would consider in that event. And I have also shown some of the judgment of our High Court, whereby it has been held that 19(1)(g) or the beneficiary, the curtailment of the beneficiary cannot coming under the curtailment of the beneficial right. Justice Vivek Chaudhary's judgment.
Fundamental right like that.
Yes. The Justice Chaudhary's judgment I have shown. There are two judgment I have shown, Justice Chittaranjan Das and Justice Sharma.
Very well.
Sipkant Prasad, I'm sorry.
Let it appear tomorrow under the same head.
Yes. Milord, one more indulgence, Milord.
Again, indulgence.
Yes, I'm sorry, Milord. There is a item number 1 in going on in the item court number 28 and the 37. So I could not come the Milord.
Item number 1.
No, item number 41 of your lordship list and the 43. In 43, I have just heard the lordship has pleased to engage Miss Sonal Sinha. Milord, in that
You are there.
I will be assisting in that event, Miss Sinha.
43. No. Mrs. Sinha. Otherwise, it will be difficult. I'll talk to Mrs. Sinha. No issue.
No, Milord, otherwise lordship can, because Miss Sinha is Milord as additional government pleader. I am the senior government. So accordingly, I am having the
Lordship, I have taken instruction. Your Lordship, Mr. Sinha, it's fine. It's okay if he does the matter and our names are, there is no issue there.
কে নিয়েছো তুমি?
I am so sorry, Milord.
No issue. কে নিয়েছে? নিপেন নিয়েছে? ঠিক আছে, নিপেনকে বলে দাও 43 আমার কাছে পাঠাতে। I'll pass the order, no issue.
Lordship has fixed it on 9th. Very grateful, Milord.
Call the list.
এটা তো নামই দেওয়া হলো না।
Lordship has recorded that in the meantime they are filing the report. Because he has said
Only I just adjourn it today.
আর কিছু না, আর কিছু।
I adjourn it today. For the day, adjourn for the day.
If this is with regard to the vacancy of 2000, my lord, the vacancy declared at my lord 2003 control order. My lord, I am challenging the control order, my lord, that is at my lord page 35, my lord. And I am covered by your lordship's judgment, my lord, that is at
1 year, more than 1 year have passed. Who are you?
No, I am the dealer, my lord. I am the existing dealer in respect of that vacancy.
Then why are you challenging this after so many days?
Earlier I moved a writ petition. Your lordship was directed me to file a fresh. That has mentioned, my lord.
What is the order?
My lord, I have mentioned that, my lord, in my paragraph, my lord,
What is the order?
with the liberty to file a fresh.
What is the order?
My lord, I shall bring board down. I have mentioned that, my lord, in writ petition.
I know. What is the order?
The order I am not annexed, my lord.
Bring the order. Come tomorrow. Bring the order. Come tomorrow.
Kindly Monday, my lord.
Okay, not this week.
56 and 57 same.
Next.
Same. My lord.
Not this week.
57 also not this week.
Not this week. Next. Next.
For the statement.
58. You are for the
State.
state. Who is for the writ petitioner? What is the issue?
The issue challenging an order of rejection of the ration cum go down shop at Dharampur by the petition by the respondent authorities. But that has been shortly challenged. My lord, I do not know whether there is any other grounds to be agitated by the petitioner. From the order of rejection, I found that this is the only point. Their application has been rejected. Page 47. It's 74.
47.
74.
74.
74.
Rejected. Candidature has been rejected.
Yes. But the plot number they are seeking for approval at page 43, my lord may kindly comes to. This is the plot of 232. Plot number 232 is on the plot where the petitioner is seeking for allotment of the go down shop for the purpose of running the shop. But the plot number 232, as per record of rights, it appears as John. That your lordship will get at page 30.
Page
30 of the record of rights provided by the petitioner. Plot number, my lord may kindly see on the left hand side, 222, 229, 232. Page 30. Third from the top. 232 is Joel, recorded as Joel. And that
they have converted it.
No, the document as to conversion is appearing from the annexures. If it is a Joel, then there cannot be any go down.
I'm for the petitioner and paying for not
Take
today.
your breath first. Cannot hear you.
I'm for the petitioner and led by Mr. Tarogan Swakar. I'm praying for not today only.
Not this week.
Not today.
Not today.
Only not today.
Very well. Come on tomorrow. Not today. Next.
My lord, I am praying for not this week.
Not this week. Forget it.
For the petition, I'm paying for not today.
Not this week. Next.
61, my lord, I am praying for not this week. 61.
Not this week.
Great.
Next. Next.
63, my lord, I am for the petitioner. This is the 2024 vacancy matter, my lord. Your lordship was pleased to direct the state to file report, my lord.
Report.
24, my lord. There was direction to file a report, my lord. We have not received any copy of any report.
63 to report.
15 July order of your lordship, my lord.
It will curtailment of the beneficiaries. Huh? May I kindly takes it up on the same 11th tomorrow at 2.
Tomorrow.
I will be taking the same point.
Okay.
My lord, the report has not come.
They have not prepared the report yet. Report ready?
Report দেবে তো? Report দেবে তো?
The accident.
Intekab alam.
Oh, I'm sorry. This is 62.
63.
63. 63 minute. The report is also not ready. Minute. I will coming up with the minute the preliminary point. Then If your lordship not satisfied, I will come up with the affidavit in that event.
Very good. Let it appear tomorrow.
Yes.
Another
with
same
the-
heading.
Tagging with the other matters.
All matter will take.
Yes, yes. Lordship was pleased to take it up at 2 p.m. I guess. Fix it at
No, not first matter.
First matter.
All matter will be first matters.
Very well. In that event, the other matter which I have short for that time, in that event also I am taking the point of maintainability. If not satisfied,
This matter you have also taken the point of it was kept open.
But the other matter just today I was doing, lordship is I have made a submission that tomorrow I will be able to place the same. If it is on 10:30, it will be difficult for me, to prepare the same. So I will be arguing on the point of maintainability, and if your lordship not satisfied, I will come up with the affidavit.
But your lordship, my lord, in the similar matters are directed for filing of affidavits in so many cases. Maximum সব কেসগুলো নিয়ে আসতে হবে।
তাই তো করছি। তাতে তো একটাই পয়েন্ট নেওয়া আছে।
I have taken up most of the cases on 26. Fixed that matter. 26. Let it appear tomorrow. 26. Tomorrow is 26.
Day after tomorrow.
No, tomorrow is the 26th. Today is 25.
Sorry.
Let it appear tomorrow. Thereafter, I will deal with all the matters.
My lord, kindly record that they have not filed report. They want to argue on the maintainability.
No, I have not said so.
No, I am not saying that. I am saying that let you record that you have not filed.
That is all right. I said I will be arguing
I have
the
given
point.
liberty to file a report.
Yes,
Only point of maintainability kept open.
Kept open.
This is the order.
Yes.
Not today only.
Not today only. If I couldn't file,
come on tomorrow then.
Yes. No. Tomorrow is the matter which I have indicated to your lordship is of the canning. So it will be rather difficult for him to
not for canning matter. All
the matter. I will be arguing.
Some matters state has filed affidavit
together. Yes.
Some matters state has not.
Yes, I will be adopting all the
yes. Affidavits are there, pleadings are there on behalf of the state.
I know.
On several matters.
In some of the matter has been left out.
Yes, some of the
matter has been
this matter and the earlier.
Correct. I bow down to you.
Not today only, madam.
Not today. Next matter.
এটাও কি সেম ম্যাটার রে? Same matter. Same.
Not today.
report নেই
না একসঙ্গে সব ম্যাটার আছে।
অ্যাডপ্ট করবে?
হ্যাঁ, আবার কি করবে?
অ্যাডপ্ট করলে আর অসুবিধা।
Next.
65, my lord, the state is to file report, my lord.
Same matter.
নামগুলো দিচ্ছিস।
Not today.
Oh, my lord, will it be better, my lord? Will it be better if your lordship gives them a week's time? Let them come with the report, because my lord, report
Some
for me
matters
is
they have
very
already filed pleadings.
in my lord, 60% of the matters they have, 40% of the matters they have not. If they want, my lord, they can take a week's time and file the report, my lord. Let everything be heard together, my lord, not in piecemeal manner, my lord, because I will be relying on the reports, my lord. And reports very important for me because, my lord, the number of cards.
Number of
There
cards.
are different number of cards.
There are different number of cards in different matters, my lord.
Very well. So,
if they want, my lord, I am not coming
exhaustive
there.
list at least, so that I can fix the matter tomorrow at a particular time.
Yes.
Otherwise, it will be difficult.
তোমরা দাও, তোমরা এক সপ্তাহ নাও, আমার কোনো অসুবিধা নেই, কিন্তু রিপোর্ট দাও।
No, all the matter appearing under the heading. Do we mention matter or
as
new motion matter?
Lordship has
Motion
fixed
mention
the
matter.
matter. Please to fix the matter for the purpose of hearing out the matter for the purpose of maintainability as I have raised.
No.
Now, just a moment. Just a minute. In the meantime, in some of the matter, Lordship has pleased to direct that the report would come in what occasions where I have taken the point. Now, the first point is that first hurdle, whether the fundamental right of the petitioner has at all infringed or not. This is the first point, which I will be arguing. Second, the reason behind the the taking the decisions which your lordship willing to see. That was the lordship's directions. Now, in some of the cases, as I understand, some of the cases, my lord, we have filed the report in the form of the affidavit.
Yes.
In some of the cases, rather I would say precisely 55 number of the cases, the affidavit has not been filed in that event. So what Mr. Huda is saying today, that he want to rely upon the reports.
Yes.
So that is his contention. What I am on today, Lordship has pleased to fix the matter on tomorrow. I will be arguing on the point of maintainability. If your Lordship is not satisfied on the ground which I will be showing or the judgment, in that event, Lordship keeps it. The left of the matters, I will be arguing on the point of
Mr. Senuta, I have taken your point.
My lord.
That's why I keep it pending.
Correct.
The maintainability keep it pending.
Correct.
For the exhaustive hearing all those matters, I want the report.
Yes. In that
That's why I
event,
have
my lord,
directed you to submit a report and your point of maintainability kept open so that I can go heard the matter.
correct.
That's
my lord,
what
I
the-
appreciate.
that's
my lord,
what- After hearing Mr. Sengupta that he will be arguing on point of maintainability, your lordship directed.
Kept open.
Yes, your lordship directed that let them file the report.
Sir, here Mr. Sengupta first.
Yes.
That is the issue.
That is what
But
I am
I
saying today.
No, no.
I am
understand.
No, my lord.
but saying
That is exactly what your lordship has recorded in your lordship's order, my lord.
Yes, I have passed the order. I know that.
After
Lordship
hearing Mr.
knows.
Sengupta,
Yes.
the point of maintainability is kept
Correct.
Open
and
along
then
with the
lordship-
report.
Yes, along with the report.
So that I can hear all the matter
Yes.
together.
So
Not
in
just
that
one
event, Lord, if your Lordship wanted to hear out all the matters together,
Yeah.
hear out all the matters
Yes,
together.
because the similar issue is involved.
Similar issue, but in some of the cases, the geographical and the beneficiaries, number of the beneficiaries are different.
That's why the report is required.
Report is there. So, in the 55 number of the cases, the affidavit is not placed before your lordship. So, what Mr. Huda is saying today, I am not opposing that. So let the matter come up after the 1 week. He will
2
also
weeks,
make
whatever you know. But let the report be filed. Let the matter be adjourned 1 week, 2 week. I have no objection.
না, না, এক week নাও কেন বলছি কারণ আমাদের তো
ওদের
সব
রেডি
লাগবে
করতে
সব আলাদা আলাদা।
ভ্যাকেশন পড়ে যাচ্ছে না।
3 দিন নেবো। I will file the report in 3 days.
10 days নেই
10 days, 3 days.
Mr. Huda has filed the reply also.
Yes.
My lord,
Yes.
let,
Your lordship has seen, my lord, in all the matters, my lord, I have filed the, I have not taken.
let there
Well,
be direction,
kindly-
my lord.
May I propose only one thing? May I propose?
Let there be direction for filing report within 10 days, reply within 3 days. Let the matter be taken up 2 weeks after.
Very well.
I will pass this order tomorrow.
Very well. Very well.
I will pass this order tomorrow so that all the
Matters,
can be taken up.
yes, correct.
How
correct,
many
correct.
matter they are?
Yes,
Let
ready?
the
How
matter,
many
yes,
matters?
yes. Otherwise, it will be
That's why I have
correct,
made it
correct,
correct.
Okay, my
Not
lord.
the piecemeal
Lordship is
way like that.
absolutely correct.
Yes.
I
That
bow
is-
down to it.
You think that this is the
Yes, yes.
correct
Absolutely, my lord. Absolutely. No
Not
doubt.
in,
Not
on
today.
Today.
Otherwise,
tomorrow, yeah.
other matter will come tomorrow. It will be difficult. Let all the matter come up tomorrow. Lordship pass the similar order.
Yes.
So instead of 10 days, they get 11 days if it's passed tomorrow.
No. So we want to dispose of the matter
NRS.
properly.
Yes,
Otherwise,
that
it
is
will
what
be
Mr. Agarwal is saying.
Before the puja, there is no concession. Only discount.
Yes, next.
66 and 67 praying for not this week.
Not this week.
67?
Yes, sure.
My lord, I am for the petitioner. My lord.
Yes.
My lord, the petitioner applied for the APS dealership, my lord, as a scheduled caste candidate and educationally qualified. And on 11/7/2024, the field verification has been completed. And on 6/5/2025, the interview has been completed. And after that, his application has been rejected without assigning any reason there. And after that, kindly come to page number 45, annexure P6.
Page number
45, annexure P6.
Yes. You made a representation.
Yes, madam.
Mr. Sengupta, you are appearing this matter?
Yes, my lord. I am appearing with Mr. Dotto.
Yes.
May I make?
Is there any report like
No,
that?
I just indicate two things, my lord.
Yes.
If your lordship sees the, my lord, the notification once, which is at page 17, I believe, 14. Kindly come to the 17. Now, 17.
Page 15.
No, page 17 comes directly. I don't want to waste the time of the court, my lord.
Page
17.
17.
17.
Yes. Yes.
Part 5. Now, kindly come to the Roman 8.
Yes.
Notwithstanding anything contained in the notice, comma, the state government may, for reason to be recorded in the writing, cancel the vacancy at any time before the approval is granted.
Yes.
So, my lord, the intention of this, my lord, the notice is that the government is playing the, my lord, the discretionary power to grant the license or to reject the license at any point of time.
Yes.
Now, my learned friend is come up with the, my lord, the representation seeking for, my lord, the reason to be known. Generally or otherwise, statute doesn't provide such practice. This is a non-statutory representation. So, for the non-statutory representation is concerned, my lord, it is not binding the authority.
My
If
lord,
your lordship so desire, in that event, what I can do is that I will come up with the, my lord, the score sheet. Score sheet will show where he actually stands in that event only.
my lord,
Because-
I am a SC candidate and
ভাই,
the
তুমি
person.
আর্গুমেন্টটা করো। হাইকোর্টে নতুন এসছো তো?
Just wait. Let him submit.
My lord, I'm sorry.
Yes.
In that event, I will show how many persons have my lord, participated in the proceedings and why the reasons for the score sheet will speak for itself.
Who is the suitable candidate will be allowed?
Absolutely, that's it. Because otherwise, the representation which has been done, my lord, kindly consider this aspect. I have seen in the many of the cases, by writing the representation, a cause of action has been created. Normally, the petitioner is seeking for a hearing to that extent, showing the same. My lord,
Yes.
there is, if the statute doesn't provide us any provision to that extent, then, my lord, our hands are tied. Since your lordship in the session of the matter, my lord, what we can do is that we can
Okay, we submit a report.
report by showing the, my lord, the score sheet and otherwise
Short
why?
report.
Yes, very short.
Not required for any affidavit like that.
Nothing.
Okay. Please take down. Petitioner applied for license in terms of vacancy notification dated. Petitioner applied for license of FPS dealership in terms of vacancy notification dated 15th of May 2024. Number page 14. Issued by SCFS Holdia. Full stop. His application was received online by giving him an application ID. It is the contention of the petitioner that he is the most suitable candidate. Instead of that, his candidature was rejected by the concerned authority without assigning any reason. Full stop. He made a representation to the authority on 24th of June 2025, which was not responded, hence this writ. Learned Mr. Suman Sengupta, learned
My lord,
counsel.
after that representation, I got a letter from them that that is, I am hereby directed to inform that as per the report of the DCFNS, Purba Mendipur, you were eligible but did not score highest marks to get the FPS license.
Then nothing
He's
left.
basically damaging his case.
Nothing left.
No, my lord, I want to show the score sheet, my lord, but just bring me the
Score sheet.
Why you want to sue?
It is absolutely clear in that event. He's damaging his case.
That's why nothing left in the
Nothing
report.
left in this. Lordship can dispose of in that event.
Yes.
Dispose it off.
Give me the
এটা দিয়ে দাও ভাই।
give me the copy. Okay, কি বললাম বল? Submits that the petitioner must not be the most suitable candidate in the impugned vacancy notification. Thus, his candidature was turned down, was rejected. Learned counsel appearing on behalf of the petitioner submits that he received a reply from the authority concerned on 31st of July 2025, informing him inter alia that he is eligible candidate but not score highest mark to get the FPS license.
There is one thing that SC candidate should be preferred rather than general candidate. The candidate
That
who
is altogether a separate issue, not in the.
My lord, I have mentioned that in the writ petition.
You made a detailed representation there.
My lord, in the representation, I have mentioned everything. My lord, kindly read. I'm reading the representation, my lord.
So, do you know one other SC candidate was not considered?
Lord,
Do you know that?
3 people are applied.
That is not the issue together to deal with. This is the factual aspect.
My lord, kindly give me the ask for the report, my lord. Kindly.
Well, why should I file the report in that event?
Okay.
I have mentioned everything in the
No,
representation. my lord.
you ask the proper representation.
My
to the
lord,
authority.
it is everything mentioned in the representation. She is a teacher. She is a para teacher at Hathibadia Urunchandra High School, and that is also suppressed. I
Let
have
kindly see when the representation was made and when the reply has come up. I believe consideration of this representation is resulted this reply.
My lord, I have mentioned everything, my lord, in the representation as well as in the petition. That in the backdoor process, this is happening. And 2 other
Off the cuff, don't make the submission on off the cuff. Come up with some relevant things or prima facie thing which court will pass an order in favor of you.
My lord, similar matter. I have 2 similar matter, my lord, where SC candidate have been deprived, and general and OBC candidate are getting the FPS license. My lord, kindly give the direction to file a report. ma'am. Kindly, ma'am.
No, you made a representation to the authority
Yes, my lord.
against your rejection. So they have
Against
assigned
my-
the reason
No,
why
against-
you have
against my
rejected.
against my rejection as well as the particulars of the candidate who got the selection, who got the license, my lord. And I have made each and everything in the representation. Kindly see, my lord.
Are you belongs to SC?
আমি এসসি ক্যান্ডিডেট।
তুমি তো মুসলিম তো।
কোথায় মুসলিম? আপনি কাস্ট কোথা দিয়ে
কত নম্বর এটা? কত
So what is the status? Selected, license
Yes,
granted.
yes, license granted, my lord.
কত নম্বর এটা?
License has already been granted.
License granted.
Then
But I
My lord,
believe this representations has been considered, and that is why this reply has
My
come
lord,
up before you
When I have
to
filed
him.
this, then license has not been provided, my lord. After that, license has been provided. After filing the writ petition, I got to know that she is selected. But after filing of the writ petition, she got the license. And
so why are
everything-
you submitting that let my representation be considered?
No,
That
no,
is
no,
what I'm filing of
I'm
this
not
writ petition.
submitting. Let my representation be considered. I'm just showing that
They have already considered representation, but your writ petition said that you have challenged the
Yes, yes,
selection of
yes.
respondent
Yes.
number 8.
Yes, yes,
This is your main grievance.
yes, my lord.
Then you submit according to the prayer of your writ, not otherwise. কি বলেছি বলো, উল্টো পাল্টা হয়ে গেল পুরো। না না বলুন।
হ্যাঁ হ্যাঁ 68, 16 and 3 আছে। না আপনি মুসলিম না ঠিক আছে।
Nice. Learned counsel for the petitioner further submits that the private respondent number 8 was selected for giving license, and now the license has already been granted. He submits that the private petitioner is a scheduled caste candidate who must be great priority to give the license. Having heard the learned counsel for the petitioner, let the respondent authority be directed to submit a affidavit in opposition against the writ petition within 8 weeks.
Lordship is
8
direct.
weeks?
No, that is all right. But the thing is that what I'm proposing, he is seeking for consideration of his the representation.
Not like that. Prayer is otherwise.
Prayer is otherwise, but
Prayer is also otherwise.
but the cause of action which has been he is relying upon, which has been already fulfilled. We have given the the reply.
I have taken note of that.
Today, if suppose he is not satisfied with the same, that is the cause of action. If he is not satisfied with the same, he have a liberty to challenge the same. That would be rather better, because today Lordship is granting the affidavit. It will be 8 weeks or otherwise. In that event, the person concerned will run the shop, and subsequently, if it has been found that some anomaly has been caused, he will not be awarded. He will not be awarded. He will not get any benefit.
Yes, yes.
The vacancy will be cleared and the new vacancy will be declared. But in that event, his fundamental right or otherwise cannot come into the way. So what I'm proposing, Lordship kindly dispose of this one and direct them to challenge this one.
No, this is not in the writ petition.
Not in the writ petition. This is the reply which they are also relying upon. This is the government reply.
No, I understand. But the issue is that prayer in the writ petition is otherwise.
Where I have seen,
only challenge the selection of respondent number 8. He submits otherwise. That is all the difficulty. Only challenge the selection of respondent number 8.
Also consider whether a unsuccessful candidate
I'll look at this matter. I understand. 8 weeks from the date of passing of this order. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list, but is elevator mentioned.
His prayer B was to consider his representation. Lordship has seen the prayer A. Prayer B was to consider his representation.
Prayer B is there.
Yes. Prayer B is there. Kindly have a look. Prayer B is there.
Forget it. He is now new. It's just. Yes. Next matter.
69, my lord, I beg to appear on board. This is the affidavit of service, my lord. Kindly come to page 24, that is the impugned notification, my lord.
24.
Annexure P1, my lord.
Yes.
But the vacancy of fair price of dealership was notified, my lord, for the place, my lord, the table that has been mentioned, my lord, Chor, Debaipur, Molladanga, my lord, Purandorpur, Purushottompur, Chor, Ghugupara, nearby Giyasuddin Masjid, my lord.
Yes.
My lord, I have applied for the such place, my lord, for the FPS. My lord, pursuant to my application, my lord, field verification was conducted, my lord. That is first field verification was conducted. That is at P4, my lord, annexure 44, my lord. My lord, though that is illegible, that is why, my lord, I have taken out a typed copy, my lord.
Page
44, my lord.
Yes.
It was, my lord, the page 43 directed to me to appear on 24th of December 2024 at 11 a.m. my lord, for FBC. For FBC.
Yes.
But after inquiry, your lordship kindly see the paper I have handed over, the typed copy, because it is illegible one, my lord, kindly. Because that's the carbon copy, my lord. The column R, my lord.
Yes.
Distance of shop-cum go down from the central point of the notified vacancy, 90 meter, my lord. This is the first one, which has been signed by the signature of the EOs, and there are, my lord, kindly see, my lord, the next the left column, my lord, the signature of the witnesses is also appearing, my lord. Though it is, my lord, kindly illegible, but the signature of the witnesses also appearing. My signature is also there, my lord. Now, kindly turn over the next annexure P5, that is page 45. On the same self day, they have conducted a second, prepare a second report, my lord, which is the kindly come to the column R. Here, the distance has been increased 4 km 720 meter, my lord. My lord, the typed copy I have annexed the earlier one, my lord. It is the earlier one, my lord, the prior page of 45, my lord, in my petition, my lord. Same date, my lord. One is 90 meter and another is 4 km 700 meter, my lord. Because my lord, the location, identification of the location has been mentioned in the, my lord, notified vacancy notification nearby Giyasuddin Masjid, my lord. So in first, my lord, on the first FVC report, they have stated 90 meter, but the same report has been prepared on the same self date, which is not bearing any signature of the witnesses. Well, kindly see the left column, bottom name of the signature of the witnesses, blank. Now, what happened, my lord? The actual scenario.
These are handed over to you.
Yes, my lord.
Both the reports.
Both the reports. My lord, actually, the village, there is a canal, my lord.
Yes.
My lord, in one side of which our godown is situated, there is a masjid which is called Giyasuddin Masjid, my lord. And also, my lord, on the other side of the canal, there is also a, my lord, masjid which is called Giyasuddin Masjid, my lord. But in the notification, my lord, it is from nowhere, it is appearing that on which Giyasuddin Masjid they are referring, my lord. Though, my lord, I have submission that the second, my lord, report, which has been prepared and stated that the area is go down is the from the central point of the notified vacancy 4 km 720 meter. From these two reports, it is appearing that the measurement of the concerned authority for adjudicating the actual notified area is, my lord, contradictory. Because if we consider the notification, which is the sole basis of the recruitment process, my lord, process, from such notification, nowhere it has been mentioned that which Giyasuddin Masjid, my lord.
There are two Giyasuddin Masjid.
It is, my lord. I am submitting
in the same Mauja.
In the same Mauja, my lord. I have made a complaint. My petitioner has clarified that situation by a letter dated, my lord, 14th of January 2025, which is appearing, my lord, P6, page 46, my lord. On the next page, my lord, I have stated that there is two Giyasuddin Masjid.
Yes.
I have stated, my lord. But pursuant to such complaint, they afforded me the hearing, my lord. I have, my lord, the page 47 onwards, my lord, the hearing was afforded. My lord, I attended the hearing.
Yes.
I clarified the situation, my lord. Instead of such, my lord, clarification, my lord, kindly come to page 52. That is my last annexure, page 10, my lord. what I only gather the information from the portal that my application has been cancelled or rejected. My most humble submission before your lordships. Your lordship, find page 52, my lord.
What is the decision of your hearing?
My lord, decision I have not been communicated with. And this, my lord, decision of rejection of my candidature, I came to know from the portal, my lord. I have downloaded this rejection information from the portal, my lord. So my submission is, my lord, from the page 44.
What is the status now?
The status now, as per my instruction is concerned, that the process has not been completed. That is my instruction, my lord, subject to correction.
So no one was selected.
Yes, my lord. That is why I have not made any, my lord, private party into this writ petition.
So what is your prayer in the writ petition?
My prayer is to cancel the annexure P10 in the light of the variance in page 44 and the 45, my lord, because they have in one field verification report they have stated, and my lord, if your lordships compare the two verification report,
I've already compared.
Everything is same except
you see the LET, longitude and latitude.
Yes.
My lord, my lord,
That is the
my lord, here I
different
join,
place.
my lord, here I join one issue, my lord. But if we go to the, my lord, the P1, the notification, it is only stated, my lord, the nearby Giyasuddin Masjid, my lord.
Okay. I've got your point. Yes.
So they if they want that Giyasuddin Masjid, which is situated on the other side of the canal, there must be. And my lord, I have the document, my lord, that Giyasuddin Masjid has the notified, my lord, there is a primary school situated just beside the Giyasuddin Masjid. So it would be, my lord, must be clarified in the notification that in which area you are.
Yes, Mr. Sengupta.
It's a very unique case.
Yes.
Whereby your lordship would see, as per the submission of my learned friend, that in the same GL number and the same plot of land, there are two Giyasuddin. If I read the vacancy notification which has been laid down, it is also clearly stipulated the envelope they contain the such and such should be such and such hamlet, Chandipur, Moldanga, Purbando, such and such, Char, Uria Pada, nearby Giyasuddin Masjid, Monza, Molidanga, GL number such and such, ward, Horship, PS such and such. In the district Murshidabad, such and such. So according to my learned friend, there are two Giyasuddin Masjid on the same plot.
Yes, same Mauja.
Same Mauja. In that event, this
number of Mauja is the very conjoined place. If there are two masjid in the same name, that would be difficult. So which portion is the notified? That has to be taken decision.
Now the thing is that Millard kindly consider also in this aspect, he has participated on the same.
Yes. He has participated. He has called for interview
also
by the district level fair price of selection.
Correct.
Prior to that, he submitted a
had it been a case, it found that there is an ambiguity in the vacancy in the notification.
By two reports.
No, I tell you, lordship. He must have filed the candidature in respect of one Giyasuddin Masjid, right? The authorities concerned has not taken into the consideration. He is being the localite, have a clear knowledge that there is two Ghiyasuddin Masjid. Two Ghiyasuddin Masjid on the same Mauja, same plot. Then it creates the ambiguity on the notifications
Yes.
itself.
Ambiguity itself and the report also, two report.
I
There are
have seen
two
the
masjid.
two report also. Lordship would see re-inquiry can be held.
Yes.
There is no question on to that.
Same day, two reports
Same
in
day.
respect of two masjid.
Yes.
That's
In
why
that
the
event,
the
in that
authority
event,
also not clear which is the
no,
masjid.
no. I tell you, Lordship, possibly the authority was in little confusion which Ghiyasuddin Masjid has been, declared for the vacancy.
Yes.
So
That's why
they
two
went
reports.
over there on a wrong process. Thereafter, they realized, no, this is not the one whereby we have to go on the vacancy notification. Therefore, the second re-inquiry has been held.
No, in the same day the decision.
Same day, of course, somebody definitely has
However,
objected.
you have already given him a personal hearing, but not take a decision on his personal hearing.
Personal hearing we have taken, he possibly the eligible candidate.
No, not that. In respect of his complaint regarding central location, you have given him a personal hearing.
My lord.
But no decision was obtained.
Page 46 bottom. What is my thing? অতএব মহাশয়ের কাছে মহাশয়ের নিকট আমার বিনীত প্রার্থনা এই যে সরকারি নিয়ম অনুযায়ী নতুন রেশন ডিলারে ঘর পাওয়ার জন্য যে ক্রাইটেরিয়া আছে তাহা পুনরায় তদন্ত করিয়া কোন লোকেশনে ঠিক আছে তাহার সুব্যবস্থা করতে আজ্ঞা দেওয়া হোক।
Now they have already inquired two locations, two central locations.
My lord, the two reports which is appearing in page
Let them submit a report. Otherwise it will be not difficult.
What is my conclusion? My lord, the second report, that is missing the witnesses also. Now,
let them submit a report.
Second report as the genuine report.
How can you say this is a genuine or this is not genuine?
Yes, my lord.
Both report they handed it over to you.
Yes.
Very well, let them submit a report.
My lord.
Petitioner applied for FPS license in terms of vacancy notification number such and such dated 24th of May 2024, page 24.
এটা আমি দেখেছি, সেকেন্ড নোটিস, সেকেন্ড তো
In terms of his notification, in terms of his application, the authority concerned inspected the proposed shop-cum godown of the petitioner on 24th of December 2024. However, after the inquiry, the petitioner was petitioners received two reports from the authority concerned appearing in annexure P4 and P5 of the writ petition. One report contained the distance of petitioner proposed shop-cum godown from central point is 90 meter, and another report contained it is 4 kilometer 720 meter. Full stop. Petitioner was confused and made a detailed representation regarding central location of the vacancy. His on 14th of January 2025. In response to his representation, he was called on in a personal interview. And he attended thereon. Thereafter, he was asked by the district level fair price shop selection committee in an interview in terms of the vacancy notification. He also attended there. Thereafter, the petitioner came to know from the portal of the department that his candidature was rejected. It is the submission of the petitioner that the act and action of the respondent authority regarding cancellation of his candidature is nullified and required to be quashed. Learned counsel, Mr. Suman Sengupta, learned counsel appearing on behalf of the state submits that the concerned authority has inspected the proposed shop cum go down and noted the distance of the shop room from the central location. He further submits that if there is two identical central location within the same moja, the authority concerned must have taken note of which is the proper central location in respect of the vacancy. He submits that to appreciate the matter, a report is required to be filed. Before this court, a report is required to be filed. Concerning the same, the authority, respondent authority concerned is directed to submit a report in the form of affidavit against the writ petition within 8 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Since it has been submitted by the learned counsel for the petitioner that no one was appointed till now, no one was selected till now in respect of the said vacancy, I find nothing to pass an interim order in this matter. Another, I find nothing merit to pass an interim order in this matter.
May I submit one?
Yes, let the matter go out of this parties elevated matter.
My lord, in the meantime, please, my lord, ask them not to engage any third party. Please, my lord.
You have submitted the nothing has been appointed there.
My instruction, my lord.
Milord,
Yes,
it has,
come with the instruction if there is.
Milord, I tell you, Lordship, Milord, I tell you, Lordship. I tell you, Lordship. I tell just আমি তোমারটা clear করে দিচ্ছি Milord, I tell you, Lordship. This matter was filed on the 2024 on the 25. Now, had it been a case, the process has been completed. The result would be, if it has been found Lordship is not satisfied on the report, then the vacancy would definitely declare as a null and void.
Yes.
In that event, the new vacancy would come. Where is the urgency of the interim order? He's been protected by your Lordship's order.
In that third party into the writ petition. I am not, my lord, I am just.
Third party দরকার পড়ে না তো এটাতে।
No one is there. You have not made any party. Why such order? In the year? No such order.
Authority, respondent authority are the correct person to submit the.
If you have some instruction, come with this court. Come before this court, I will pass the order. No issue. Liberty to mention is there already.
My. Get it. 70.
Next.
71, I am for the private respondent, my lord. 14.
Which for the
Respondent
petitioner?
number 14.
Oh, I'm for 30.
You for 13, I know.
I got scared that she's against me.
71.
I'm for 13. I'm for respondent number 13.
Respondent number 13. Who is for the other petitioner? No. Who is the petitioner?
Some is Gopal Vishwash.
Not this week. Next.
My lord, I am for the petitioner. Similar kind of matter. I belong to OBC candidate, SC category, and the appointment given to the OBC category.
No, whatever may be. That is not the issue altogether. Who is the private respondent? Have you served?
Yes, ma'am.
Where is the affidavit of service?
My lord,
You come with the affidavit of service, otherwise I cannot take up. Private respondent is there. File an affidavit. Only one
one private respondent.
Serve him, come with the affidavit.
My lord, When I have started that time.
Affidavit service থাকলে দাও।
Give me the affidavit of service.
That report is not there because.
Very well. Come on next week then with affidavit of service. No, no, without affidavit, I shall not take up any matter. Yes, next.
Just one humble request, joint request from me and Dr. Miller. In item number 71, if you also can kindly record for the one line that none appear on behalf of the petition. So that next week.
Item number 71.
Yes.
70 ওটাও
Item number 71 টা note করুন তো, none appears on behalf of the petitioner. Private respondent as well as the learned as well as the state respondents are represented.
We are both for private.
Both are private
My lord, the
respondents.
state respondent, Mr. Susuman Sengupta, appearing, my lord, he is on legs in court number
71.
71.
Okay, private respondent as well as the state respondents are represented through their learned counsel. Let the matter appear next week under the same heading. Next, 73.
স্যার আপনি কি প্রাইভেট না স্টেট ও আছে সোনাল সিনহা ঠিক আছে সোনাল সিনহা
70 shall also appear for the petitioner, my lord.
না নেই রিজন অর্ডার
And may I file the affidavit of service, my lord?
হ্যাঁ বলছেন না আমি তো সবে এসেছি স্যার কোন
May I make a very short submission, my lord? So far as 73 is concerned, I am appearing for the petitioner. But this is an application, my lord, praying for compassionate appointment, my lord. If your lordship, my lord, wishes to, my lord, give an opportunity to the state to file a report, my lord, then your lordship can give, my lord, pass such direction, my lord. Or if your lordship wants to dispose of, they do not want to file a report, my lord, in that case, lordship gives me a week's time, my lord. I'm in some difficulty, my lord, so that's matter is concerned.
Do you have the proper instructions?
My lord, yes, we need.
You have the proper instructions.
As of no, we do not have any proper instruction. I just
have any proper instructions?
no, my lord. Only I can highlight you reasoned order, my lord. Kindly
Okay,
come.
reason order is there.
Reasoned order is there.
So you have challenged the reason order. So
Reasoned order is there, my lord.
let it appear
2
tomorrow, next week.
Next.
He is not ready. Okay.
And
Not this week.
So they are not filing any report in that case.
No,
Not
they have coupled with the reason order. So
Perfect.
why they
My
say
lord, no,
perfect, lord, perfect. Kindly take it up next week.
next week? Next,
not this week.
Right.
not this week.
My lord, 70.
I am appearing on behalf of the petitioner, my lord.
Mr. Susuman Sengupta appearing, he is on legs in court number 10, my lord. Kindly short pass over. Short pass over.
For the state.
Huh.
Okay,
74 and 75.
74 and 75.
Huh? কি বলবো?
My lord, liberty to file supplementary affidavit on behalf of the petitioner, my lord, and my affidavit is taken on
Have you
record
served?
tomorrow. Yes, my lord.
Have you served the supplementary?
Yes, no, no, my lord. Supplementary not served. Ready. Ready to hand it over the copy.
Give me 74 first. Give
May
me
I hand it over
74.
one copy supplementary affidavit just now to
Just
the
now,
learned
let us
counsel for the state respondent. Supplementary affidavit and affidavit of service.
Affidavit of service filed on behalf of the petitioner be taken on record. Leave is granted to the petitioner to file supplementary affidavit. Copy of the supplementary affidavit be served. No, copy of the supplementary affidavit served upon the learned counsel appearing on behalf of the state respondent.
Just now I started.
Let the matter appear tomorrow under the same heading.
Much obliged.
Leave is granted to the petitioner to file supplementary affidavit in connection with the writ petition. Copy of supplementary affidavit is served upon the learned counsel appearing on behalf of the state. Okay? No, I am not taking up today. Just wait. He has just given a supplementary affidavit.
Yes,
He has just given a supplementary affidavit. Let it appear tomorrow.
Tomorrow, my lord. Tomorrow, one matter is because my lord will be actually my lord is taking up this matter in the morning. Then I will go.
This matter?
This
No. Tomorrow I will take up after 12.
Subject to harassment. My lord, I am leaving it.
Tomorrow you have some difficulty.
Yes,
Very well.
ব্যাপারটা
So next week then, next week, next week. Let
And
the matter
75
appear
also.
under the same heading. 75, are you giving any?
My lord, I am 74 only. I am appeared on
Very well.
74.
Very well. 74 hourটা করো, not this week করে. Let the matter appear in the list in the next week under the same heading.
Well, supplementary evidence they have.
হ্যাঁ হ্যাঁ
Did there be an order?
হ্যাঁ হয়েছে
Because-
হয়েছে অর্ডার হয়েছে
Oh, order হয়ে গেছে?
বকছো কেন অর্ডার হয়েছে দাদা
Call next matter, 75.
75
75, 76, and 77 not paying for not this week, my lords. Same
I am
matter.
appearing for this request along with.
okay
75.
75, 76
76 and 77.
is, my lords.
On the prayer of the learned counsel for the petitioner, let the matter appear in the list on 1st of September 2025 under the same heading.
Obliged.
Passed over item 52 was there. Passed over item.
Yes. Call the past over item. You are there.
I am there also.
Call 52.
Sorry, tender my apology, my lord.
Very.
This is the affidavit of service. A very short prayer, my lord. Now, not praying for any interim order, perhaps there is no scope as well. So, a very short prayer, my lord, which I make, my lord, kindly comes to, my lord, paragraph 6 of my writ petition. That is the gamut of my allegation. My lord, I had participated for a fair price ration shop. Respondent number 7 had also participated. Now, my lord, I believe it's my apprehension on instruction, my lord, I'm saying that, my lord, on inspection, I have found out, my lord, the requisites which were required to be fulfilled, my lord, was not fulfilled by the respondent number 7. Now, my lord, I am apprehending that he might be granted the license. So, my lord, I am still at dark because I have not been granted. So, that is the subject matter of the writ petition.
What is the status of your candidature? Rejected.
Yes. Scored 0.
So,
And
my lord,
private
I only
respondent-
want that to come by way of an affidavit because, my lord, to know whether, my lord, why I am rejected and why the person who has been selected, whether he fulfills the criteria or not. That's only a prayer of stature I am, my lord, I am seeking for.
Then you have made a representation to the authority. Why before this court?
Lord, I had come because, my lord, on an
Well,
apprehension.
the private respondent has already been issued the license.
That
and
is
she-
why. That is why, my lord, I come before this court.
And
But I
she is running
apprehended
the
that
shop,
there is
my
some
lord,
foul
since
play.
23rd of June 2025, she is running the shop. Private respondent.
My lord, kindly
She
come.
has scored, my lord, 63 and the petitioner scored 0.
Now, kindly comes to
Yes.
paragraph. Yes, that's the part, my lord. That is why I say, my lord, there is a foul play.
My written instruction is there.
Now, let them come with an affidavit, my lord, disclose what criteria he has fulfilled and what I have not fulfilled. Because, my lord, I have filed an application.
Is there in the notification?
But yes, it is there in the notification and I kindly comes to paragraph 6 once.
You have the eligible.
But I say that I have the eligibility, I have fulfilled all the criteria.
You show by furnishing document that you have the eligibility.
But I had specifically said that, my lord,
That
kindly
you have the proper go down, you have the proper
Yes,
location.
proper
you
go down. That's the only reason that his candidature has been
have
rejected.
the proper land.
My lord, land documents, my lord, I have annexed.
Dokan commercial bastu, all are jol land. You show
Well,
at
this
least
is-
one
My lord,
document.
kindly see page 18, 19
Page 18.
and 19 of the writ petition.
That is your fees.
No, my lord, 18 after this, I'm sorry, 19, my lord.
Yes.
But this is the Moja, my lord. I have given the map and the description of the land.
Well, unsuccessful candidate, my lord, whether can file a petition, my lord, questioning the process.
Only question, my lord, whether, my lord, on what
Cannot be
grounds
done.
I have been rejected, my lord, whether I have a right to know or not. But I am not saying that to cancel his.
Then you file a representation to the authority. Why before this court?
The representation, my lord, would be an idle formality, my lord. Today your lordships can direct. Because, my lord, what is there is there. Nobody can improve. Neither can I, neither the private respondent, nor the state.
The
There has to
private
be some
respondent has been
foundation.
served on, or I don't know whether private.
Everybody has been served. Everybody has been served. But there has to be a foundational basis of rejection of a person who is scoring 0, which seems very absurd, my lord. Now, 0 is very absurd when I make a specific averment that my apprehension is that the respondent number 7 will be granted the license. I have a specific, my lord, contention. So, my lord, I must have a reason to believe that there is a foul play.
So he doesn't want the license. He wants to know.
No,
So
obviously I want the license, but my lord,
the RTI Act.
I am being
Get
told,
information on the RTI Act.
told even at the time of application that you do not satisfy, this person satisfies. Now, my lord, whether I should have an opportunity to know or not, how he satisfies
That
it.
you get under the
It's a
RTI
public
Act.
document, my lord. The state has the document.
If I may hand down the comparative
Question is
chart.
whether you have made a representation.
Representation, my lord, with deepest of respect, my lord, I say representation is only with regard to what? My lord, I have made a prayer, a grievance is there. Today, my lord, I am apprehending that I am in a place where I should be entitled to get a license. I am apprehending that somebody else might get it out of an way.
Not
So that
apprehension,
is why, my lord, I had
Already.
given license.
that was never communicated to me. That was never known to me.
You are the local person, you know license is there.
But I had only apprehended that he was given. But I wanted to know. That is why, my lord, I say,
Apprehension, I understand if you come before giving the license.
Lord, with deepest of respect, my lord, what harm will be caused if the state files an affidavit disclosing the documents?
No,
Why?
that is not the issue.
It's
Issue
not
is
a
that
matter
you have
of
to make
courts.
the Total representation to the state. Why I am given zero?
And writ petition without
Then, my
demand
lord,
for
she
justice
grants
is not
me liberty.
maintainable.
Grants me liberty, my lord, puts it there, my lord, I'll file a representation. That has to be adjudicated.
Okay.
Adjudicated. Very
Very good. Please take down.
Kindly record my submissions, my lord. The private has already been given.
Yes.
And she scored, my lord, 0. And the private has scored 63. I have got, my lord, written instruction.
Okay.
If I may hand up, my lord, to the rich.
No, that is what, my lord, I was
to hand over. Just take it.
Very well. Very well. Kindly record my submission.
Petitioner applied for FPS license in terms of vacancy notification number such and such dated 15/5/2024, page 12. Petitioner submits that his proposed shop cum godown was inspected. He was participated in the entire selection process, but the state authority has state authority without assigning any reason has rejected the candidature of the petitioner, and he is in apprehension that respondent number 7, private respondent number 7 would be given the license. He submits that as the state has not assigned any reason regarding the rejection of the regarding rejection of his candidature, state may be directed to submit a report in the form of affidavit
as to on what basis, my lord?
stating all the reasons for his rejection. Stating all the reasons for his rejection. Mr. Dotto, Mr. Sopon Dotto, Learned Senior Counsel, AGP, appearing on behalf of the state, submits that the present petitioner has no locus standi to file a writ petition. Has no locus standi to file a writ petition. The present writ petitioner has applied for license, but after thorough deliberation of the authority
and the
in the
scrutiny and
selection
inquiry.
process, the petitioner has scored only 0 marks. 0 marks, but the selected candidate, that is the private respondent, has scored 63 marks.
Scored 63.
63 marks.
63.
63. The petitioner, being an unsuccessful candidate, cannot maintain a writ petition.
And there is no demand for justice or even a representation for moving a writ
However,
petition.
the petitioner has not approached the authority asking for the reasons for his representation, reasons for his rejection. Having heard the learned counsel for the parties, it appears that the petitioner may have scored 0 marks, but he has the right and liberty to know the fate of his candidature in proper manner. However, the petitioner has not made any representation. On that score, I direct the underscore underscore the instant writ petition is disposed of with a direction to the petitioner to approach the authority with a detailed representation, asking them regarding the reasons for his rejection within 2 weeks from the date of passing of this order. Full stop. The authority concerned shall dispose of the representation of the petitioner according to law, after giving a reasonable opportunity of being heard to the petitioner within 6 weeks from the date of receiving of the representation. Full stop. The decision of the authority shall be communicated to the petitioner within 2 weeks thereafter. Next para, I make it clear that this court has not entered into the merit of this matter. The authority concerned shall independently take the decision according to law without being influenced by any observation of this court, without being influenced by any observation of this court. Full stop. Next para, since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted.
Well, your lordship has been pleased to record my submission that private has already been given license and she is running the shop.
আচ্ছা ওইখানে করে
Kindly record that.
0 and 36 যেটা করেছি না ওইখানে Mr. Dotto further submits that the private respondent has given the license by the authority and has given the license of the authority, license by the authority
On 23rd of June 2025.
license of FPS by the authority on
23rd of
June 2025
and she is running
the
since 1st of July
she
2025.
is running the business since 1st of July 2025.
That's my written instruction. That's
Okay,
why.
okay.
Grateful to your lordship.
Disposed of. Next.
I am praying for not to the lordship.
Not this week. Next.
Yes, your lordship. First aid led by Miss Sinha.
My lord, in this matter, private respondent is there, my lord.
You are appearing?
For the petitioner.
Petition. Private respondent
Is
is
there.
not serve.
I have served, my lord, but I could not, my lord, prepare the, my lord, the
He
affidavit.
is appearing.
No.
Very nice, my lord. I'm to.
No, private na.
Okay.
My lord, 1 week.
What do you want?
Only one, my lord. The only point is this, my lord.
No. Whether your affidavit is ready?
No, my lord.
Affidavit of services is not ready.
That is why.
Okay, come on, not this week.
My
Your
lord.
lordship.
81 I put the petitioner. But I have solved, my lord. The petitioner has come up before your lordship, my lord, for challenging the vacancy notification, my lord. By publishing this vacancy notification, my lord, the service area of the petitioner has been bifurcated. But kindly see page 24 P3. This is the my lord, vacancy notification. My lord, service area is my lord, Horipur and Itanda. My lord. My lord, these two my lord, area is my lord, allotted to the petitioner for MR dealer. My lord, since my lord, 1997, my lord, he is continuing the my lord, MR dealer and MR ration shop, my lord. And now, my lord, they have published this notification. Though, my lord, the petitioner is the my lord, ration card holder of my lord, I have stated in paragraph, my lord. Page 8, paragraph.
What is the total number of DRC population?
6860.
Your?
Yes, my lord, my. And as per guidelines, we have annexed one guidelines for my lord, vacancy notification, my lord. Well, the new vacancy notification can be published if the population is more than 12,000.
That is 21.
Yes,
that is 21.
Yes.
Thereafter 23, 22 notifications are there. Why you not annexed it? This court know everything. Same issue is going on there.
Yes,
Calling for report like that.
Kindly stay the.
How can I stay this? You have more than 5,000.
Yes, my lord, 6,800, my lord.
23 notification is at least 5,000 existing. You have to retain only 5,000, not more than that. This is the notification you have not challenged.
That producer I have not challenged.
Then you have to file a fresh writ petition. Where is the notification? What is your prayer?
Prayer, my lord, for setting aside the vacancy notification. Can you see my page 14?
There are other notifications regarding policy of the state. 2022, 23, two policies are there. Why you are not annexed these?
Then kindly allow us to supplementary by US supplementary I shall annex, my lord. And
okay. Petitioner is given liberty to file. Leave is granted to the petitioner to file supplementary affidavit. And how can you file the supplementary prayer is not there? You file a afresh. Yes, afresh. Having heard the learned counsel for the petitioner, the incident petition is disposed of with a liberty to the petitioner to sue afresh on the self-same cause of action. Disposed of.
Let me.
No more.
My lord, this matter has been mentioned by someone and has been filled by your lordship for hearing. This is motion stage matter, my lord.
Motion stage.
My lord, it was motion stage and it was due to appear along with one Saurabh Mahapato, that is 207. Because both matters are challenging the same vacancy. Let it appear tomorrow as mentioned matter, my lord.
Who is the petitioner here?
My lord,
You are the for private respondent.
My lord, I am for
Let it
both
be
the
called.
matter.
Let it call the matter.
My lord. But 207, your lordship will kindly mark along with this.
207 today's list.
Yes, my lord. Should be heard along with this.
207. Okay.
My lord.
Call the matters.
Item number 3, I am led by Mr. Supratim Dhar, learned senior advocate, my lord. My lord, this matter relates to the illegal utilization of petitioner's land, wherein petitioner initially approached before the Honorable High Court for mutation, seeking for mutation. Thereafter, no objection was raised. My lord, the concerned municipality was directed to initiate a mutation proceedings, my lord. Thereafter, a decision has been taken that has been, since that property has
They are
been
using
utilized
the land as a park.
my lord, the property has vested to the state of West Bengal. My lord, may I continue? My learned senior friend will come and join, my lord.
You have concluded your submission, I think.
There are certain judgments which are
Yes, certain judgment you wanted to rely. So who is for the state? Mr. Chandicharan Dev is there? No.
My lord,
Mr. Ghosh was there.
Ghosh for
Mr.
the
Ghosh was there for KMC.
KMC, my lord. Alok Ghosh.
Where is Mr. Ghosh? They are the answering respondents. Your stand is that they have utilized your land, but
Without
without
any
giving
acquisition.
any
any
property, any money,
Without
anything. Yes, you place the judgments.
My lord, first judgment which I would rely upon is reported in 2002, volume 4, SCC 134.
Yes.
I'm supplying, my lord. My lord, basically para number 10 of the judgment. The principle which I am relying upon is my lord, paragraph number 10. It is settled position of law that the state or its executive officer cannot interfere with the rights of other unless they can point to some specific provision of law which authorizes their act. A constitution bench of such and such held that the state and its executive officer did not have any right to take law into their own hands and remove a person by an executive order. The court further observed, my lord, this is our case that with the KMC authority, without any acquisition, without any showing any basis of utilizing the writ petitioner's land, have my lord, have built a park over my Raiti land and is utilizing without having any without taking any resort to the legal provision of my lord law. My lord, this is the principle which I am. Here the basis is that since they are utilizing the land has vested to the KMC authority without there being any acquisition, without there will be any other procedure.
Yes.
My lord, the my lord, প্রথমটা এটা রিলাই করেছি এক্সিকিউশন এটা দিন এটা দেব এটা
I'm sorry, man. I'm taking over.
Yes.
My next. My learned junior has already relied that 2002 volume 4 SCC page 134 that state cannot take the property of its own citizen
without any due process of law.
Yes.
Now, my lord, my next judgment, my lord, I'd be relying on 2010 volume 1 CHN page 661. That is, my lord, in respect of a property where Port Trust is the owner of the property. KMC has constructed and, my lord, regulated the traffic, and the construction and maintenance was done by the KMC. So KMC wanted to, my lord, by invoking section 343, tried to establish the fact that they are the authority and they have a, in terms of section 343, they can collect the parking fee from that area. But the Honorable Single Judge has held, no, that power is missing under section 343.
Paragraph.
Kindly come to second page, where section 343 has been quoted. Vesting of public streets, squares, parks, and gardens in the corporation. It has got it.
Yes.
Yes. All public street, squares, parks, and gardens in Calcutta, including the soil, subsoil, side drain, footpaths, pavements, stones, and other materials, and all erections, materials, implements, trees, and other things provided therein shall vest in the corporation, provided that no public street, square, park, or garden which immediately before the commencement of this act vested in the government, the Board of Trustees for the Port of Calcutta, or the Board of Trustees for the improvement of Calcutta shall, unless so directed by the authority competent to take a decision in this behalf, vest in the corporation by virtue of this section. Subsection. This subsection 2. The state government may by notification transfer to or take over from the corporation for a limited period for the purpose of proper maintenance or development of any public street, square, park, or garden. Then subsection 3, the corporation shall transfer to the Board of Trustees for the improvement of Calcutta or to any other statutory body such public street, square, or other land as the provisions of section 54 of the Calcutta Improvement Act 1911 require, or the state government may direct as the case may be. Any street laid out or altered by the Board of Trustees or the for the improvement of Calcutta or by any other statutory body shall vest or revest in the corporation in accordance with the provisions of section 65 of the Calcutta Improvement Act 1911. Well, I'm not placing the other two subsections. Now I'll kindly come to the next paragraph. It appears from the proviso to subsection 1 of section 343 of the Calcutta Municipal Corporation Act 1980 that no public street, square, park, or garden which immediately before commencement of the above act vested in the Board of Trustees for the Port of Calcutta, unless so directed by the authority competent to take a decision in this behalf, vest in the corporation. Therefore, I find no substance in the submissions made on behalf of the CMC, Calcutta Municipal Corporation, that the public roads under reference have been vested in the corporation for conversion of those plots of land into public roads or for dedication of those roads in favor of the public. Then, my lord, kindly turn to the next page. At the bottom portion, my lord, consequent upon the above observations and discussions, this, I'm sorry, my lord, by the nature, my lord, is page, my lord, second last page, my lord, kindly come to first paragraph. By the nature of user or road or a street may be for public use, which presupposes that its nature of user cannot be changed, but it would not create any right in favor of the CMC, Calcutta Municipal Corporation, unless the same is vested in the Calcutta Municipal Corporation in view of the provisions of proviso to subsection 1 of section 343 of the Calcutta Municipal Corporation Act 1980. The corporation cannot exercise any, kindly mark this sentence, the corporation cannot exercise any proprietary right in respect thereof, nor the corporation is entitled to lease out the same for realization of license fee. And my lord, kindly come to the last paragraph. Consequent upon the above observations and discussions, the application stands allowed, restraining the CMC from making any attempt for realization of parking fee over the public roads under reference. So property was with the owner of the property was the port trust. Corporation said, oh, we have been maintaining as this is a road, hence we have a right to get the parking fee or licensee fee. That was deprecated. That they do not have any proprietary right in respect of this property. Now, my lord, kindly, I'll be relying on very recent judgment of Honorable Supreme Court. Here, my lord, Honorable Supreme Court has formulated few guidelines. And again, one of the cases, it went up from our state, and the litigant was again Kolkata Municipal Corporation and another. Here, kindly come to straight away to page. Kindly come to the first page, Malad. What are the sub-rights? A post-colonial reading of the Constitution cannot limit itself to the twin components of public purpose and compensation. The right to property. The binary reading of the constitutional right to property must give way to more meaningful renditions, where the larger right to property is seen as comprising intersecting sub-rights, each with a distinct character, but interconnected to constitute the whole. These sub-rights weave themselves into each other, and as a consequence, state action or the legislation that results in the deprivation of private property must be measured against this constitutional net as a whole, and not just one or many of its strands. What then are these sub-rights or strands of this Swadeshi constitutional fabric constituting the right to property? 7 such sub-rights can be identified, albeit non-exhaustive. These are the duty of the state to inform the person that it intends to acquire his property. Here in the previous round of litigation, court has categorically asked the learned lawyer whether your client wants to acquire this land. Answer was
yes,
negative. Then, my lord, kindly come to Roman 2. The duty of the state to hear objections to the acquisition. So first is that expression of the intention from the state. Then the state must invite the citizen that your right of objection, and first intimate that you have a right of objection, and please do come forward with your objection. Then, my lord, Roman 3, the duty of the state to inform the person of its decision to acquire the right to a reasoned decision. That what would be the fate of that objection? Whether his or her objection is entertained. If not, what is the reason behind it? Then, Roman 4, the duty of the state to demonstrate that the acquisition is for public purpose. The duty to acquire only for public purpose. The test of public purpose has to be fulfilled. Then 5, the duty of the state to restitute and rehabilitate the right of restitution or fair compensation. Then, my lord, kindly come to Roman 6, the duty of the state to conduct the process of acquisition efficiently and within prescribed timelines of the proceedings. The right to an efficient and expeditious process and the final conclusion of the proceedings leading to vesting the right of conclusion.
Yes.
So all along, my lord, from my lord, don't know, my lord, more than 40-50 years, my lord, we have been asking state to show is there any acquisition proceedings had ever started. They could not come up with any RTI answer to that. Thereafter, we came before this writ court. Writ court had adjudicated the previous lease. In that lease, nobody had questioned my title. Rather, it was asked from the court whether KMC wanted this land. They want to acquire this land. No answer to that.
Yes.
Now, my lord, kindly come to page 538 of this judgment. In this factual aspect, my lord, kindly come to page 538. This is the held portion.
538.
538. My lord has got it. On the left hand side, my lord, will find the pagination. 538. On top.
Yes.
My lord has got it. Kindly come to the health portion. Supreme Court has discussed all the provisions of KMC, whether KMC has the power, independent power to acquire a land. That has been discussed. There is no such power of compulsory acquisition of immovable property under section 352. Then the impugned orders of the High Court correctly ruled that there is no such power of compulsory acquisition of immovable property under section 352. An interpretation of the text and the context in which section 352 is placed also indicates additional reasons why the acquisition was illegal. There is no merit in the alternative argument of the appellant corporation that there is a provision for compensation under section 363. When land is acquired under section 352, the mere presence of power to acquire coupled with a provision for payment of fair compensation by itself is not sufficient for a valid acquisition under the constitutional scheme for the acquisition of immovable property. Kindly mark it, my lord. That is not sufficient. Then the next paragraph, the minimum content of the constitutional right to property under Article 300A. Before the amendment, it was a fundamental right.
Yes.
After the amendment, compromises 7 sub-rights, which I placed, or procedures such as the right to notice, hearing, reasons for the decision to acquire only for the public purpose, fair compensation, timely conduct of the procedure, and finally the conclusion. Interpreting authority of law in Article 300A of the Constitution clarifies this. These sub-rights have synchronously formed part of our laws and have attained judicial recognition. Therefore, as Section 352 does not provide for these sub-rights or procedure, it can never be a valid statutory power of acquisition. Now, my lord, in the touchstone of this, my lord, kindly come to the next page. That is at page 539. My lord, come to the that bold heading, the head note, that is the purpose and object of Section 352, clarified by distinguishing its context and placement from those of Section 535 of Kolkata Municipal Corporation Act 1980.
Yes.
A close examination of the text of Section 352 located in chapter 26 of 21 of part 6 and its context and placement clarifies its purpose and object. The text of Section 352 provides that the municipal commissioner may acquire any land required for the purpose of opening, widening, extending, etc. of a street, square, park, etc. The purpose of Section 352 is to declare that if the municipal commissioner is of the view that any land is required for the purpose of opening a street, park, etc., such land may be acquired. Section 352 does not provide the acquisition process. Once the municipal commissioner decides to acquire land, instead of Section 535 titled Acquisition of Property, provides for the acquisition process and is placed in chapter 38 part 8, 33 of part 8. Section 352 merely contemplates the power and duty of the municipal commissioner to identify the land intended for opening a street, park, etc. Once that decision is taken, the municipal commissioner would take steps to acquire such a property for a public purpose.
Yes.
The context in which Section 352 is located in chapter 21 of part 6 relating to streets and public place also makes the position clear that Section 352 relates to the vesting of public streets, squares, parks, and gardens in the appellant corporation, but does not provide for the power of acquisition. The text and context of the expression the municipal commissioner may acquire in Section 352 do not constitute the power of acquisition. In our case, Section 343 even does not have that power. Now, I'll be also placing that conclusion part and the following A, B, C, D placentum. Kindly note that,
Yes.
I'm not placing. Conclusion, I'll be relying on that conclusion part, and on the right hand at page 540, A, B, C, D placenta. And Supreme Court has extensively discussed about the power of acquisition of KMC in this matter. Oak plantation. Now I'll be relying on this judgment on the principle of
Okay.
Now, my lord, I'll be relying on another judgment, that is koi judgment koi oh हाँ. मतलब the 1999 मतलब 5 SCC page 590 on the proposition of para 26. Twenty-four, 25, 26.
Paragraph 26.
26. It would be a never-ending process. Why this rule of estoppel? Why this res judicata? Why this constructive res judicata? All principles been discussed in this judgment, and Supreme Court has held this is for the public policy. Otherwise, a lease, LIS lease, would not ever ended. In the previous round of litigation, KMC has not objected regarding my title. KMC has not come forward by saying that, yes, we wish to acquire this land. KMC has not, though there was a specific question been made or asked from the bench, but no authority, not even by the state, has ever claimed this property was acquired by invoking any due process of law.
Yes.
Now, Malad, kindly come to page 26. Malad, page 24, 25 and 26. Malad, kindly come to page 26, para 26.
Yes.
It is settled law that the principles of estoppel and res judicata are based on public policy and justice. Doctrine of res judicata is often treated as a branch of law, branch of the law of estoppel, though these two doctrines differ in some essential particulars. Rule of res judicata prevents the parties to a judicial determination from litigating the same question over again, even though the determination may even be demonstrably wrong. When the proceedings have attained finality, parties are bound by the judgment, are stopped from questioning it. They cannot litigate again on the same cause of action, nor can they litigate any issue which was necessary for decision in the earlier litigation. These two aspects are cause of action estoppel and issue estoppel. Cause of action estoppel and issue estoppel.
Yes.
In previous round of litigation, I came before this court because KMCA is not accepting my application for mutation. This time they will come and say, now Malad, kindly see the cause of action in this writ petition. Cause of action is different. No. On the second part, an issue estoppel. Not only cause of action estoppel, issue estoppel is also vital. These two terms are of common law origin. Again, once an issue has been finally determined, parties cannot subsequently in the same suit advance arguments or adduce further evidence directed to showing that the issue was wrongly determined. Their only remedy is to approach the higher forum if available. The determination of the issue between the parties gives rise to, as noted above, an issue estoppel. It operates in any subsequent proceedings in the same suit in which the issue had been determined. It also operates in subsequent suits between the same parties in which the same issue arises. Section 11 of the CPC contains provisions of the res judicata, but these are not exhaustive of the general doctrine of res judicata. Legal principles of estoppel and res judicata are equally applicable in proceedings before administrative authorities as they are based on public policy and justice. Now, my lord, kindly come to the section 343. Oh, Malad, before I go to Malad, section 343, Malad, kindly. Paragraph 46. Para 46 to 49, Malad, I'll be relying. This is on forcible dispossession.
Yes.
When it states or Article 12, authority of a state's duty is, as we have learned from my lords, that to protect the property of a citizen, not to take away the property of a citizen without any due process of a law.
Yes.
Even a trespasser cannot be evicted forcibly. Thus, a person is illegal occupation of the land has to be evicted following the due process of law. Then, the other things all been discussed. 49 ta kothay? Then the kindly come to paragraph 48. Even the state authorities cannot dispossess a person by an executive order. The authorities cannot become the law unto themselves. It would be in violation of the rule of law. The government can resume possession only in a manner known or recognized by law, not otherwise. The forcible eviction of the applicant by the respondents was unwarranted and unlawful. Proceedings had been initiated under the 1982 Act. It is a special act to prevent, this is a different set of facts. In our case, they have invoked 343. 343 to kothay? Amar affidavit in opposition. Now, kindly take my affidavit in opposition where they have quoted the entire section 343. Or my lord can look it from this book. Anna?
Yes.
Now, Lord, kindly come to in the discourse provision of section 343 subsection 1 of the KMC Act 1980 is hereby reproduced. All public streets, squares, parks and gardens in Calcutta, including the soil, subsoil, side drain, footpaths, pavements, stones and other materials, and all erections, materials, implements, trees and other things provided therein shall vest in the corporation. Then proviso clause, provided that no public street, square, park or garden which immediately before the commencement of this act vested in the government, the Board of Trustees for the improvement of Kolkata shall, unless so directed by the authority competent to take a decision in this behalf, vest in the corporation by virtue of this subsection. Then subsection 2. The state government may by notification transfer to or take over from the corporation for a limited period for the purpose of proper maintenance or development of any public street, square, park or garden. This relates, this is a right between state government vis-a-vis of KMC. If state government wants, state government can take it from the KMC. Then subsection 3, the corporation shall transfer to the Board of Trustees for the improvement of Kolkata or to any other statutory body such public street. This is again corporation can transfer.
Yes.
Then, my lord, 4, any street laid out or altered by the Board of Trustees for the improvement of Kolkata or by any other statutory body shall vest or revest in the corporation in accordance with the provisions of section 65 of the CIT Act 1911. Then subsection 5, the corporation shall maintain a register in such form. This is regarding only maintenance of
register.
Then register. Then subsection 6, the corporation may publish in such form and in such manner as may be prescribed the contents of such register of sale to public. In view of the law laid down, in their recent order sheet, in view of the law laid down in subsection 1 of section 343 of the KMC Act 1980, the property shall be deemed to have been vested in the KMC, free from all encumbrances by operation of the law. I am afraid to say,
yes,
their recent orders say that since they have invoked subsection 1 of section 343, the property got vested. So no requirement of acquisition, no requirement of requisition, no requirement of paying compensation, nothing is required. Only invoking of subsection 1 of section 343 will be enough.
Yes.
That is their
Affidavit.
Affidavit and the recent order. Even recent order, my lord, which is at page 2021, 4th June 2025. My lord has got it. My lord, at page 20 of my affidavit in opposition.
Yes.
Page 21, kindly come. Kindly come to the bottom portion at page 21. Two paragraphs. In view of the law laid down in subsection 1 of section 343 of the KMC Act 1980, the property shall be deemed to have been vested in the KMC, free from all encumbrances by the operation of law. Then following paragraph, in view of the provisions of the law quoted above, the application for mutation of unassessed plot of vacant land could 21 kathas could not be considered, and thus it stands rejected as the same has been vested to the KMC. Vested to the KMC by operation of the law itself. What is that law? 343. 343 does not state about the or envisage the power of acquisition of KMC. That is in some other section. Even Supreme Court has deprecated that sort of a practice, and Supreme Court has held, no, that is the power of the commissioner to say that that particular land is required or for the purpose of public purpose. Then KMC has to put up a formal request before the actual acquiring authority, that is the state. Then thereafter, state will proceed with the acquisition process, and after due payment of compensation, after all other stages, those all 7 sub-rights which has been appended in that judgment, Supreme Court has said after the completion of those rights, those exercises, only KMC can say that they have the power.
Yes.
Or that power has to be exercised through state. So, my lord, in this case, my lord, from the very inception, it was the stand of the Article 12 authority not to pay the compensation, not to pay requisition compensation. Even in my previous writ petition, there was a prayer made, but they were asked, they were given option by the Honorable Justice Dipankar Datta. Even they declined to accept that offer.
Yes.
Today, now they come and say in 2025, saying that no, this has been vested
By operation of law.
by operation of. So this is my
Okay. So I'm fixing another date for their argument.
Malad.
Please take down. Argument on behalf of the petitioner concludes. Let the matter appear in the list on 10th of September 2025 for argument on behalf of the KMC at 2 p.m. 10th. 2 p.m. as a specially fixed matter.
In default, kindly, they are evading. That's the problem.
The last occasion there, Mr. Ghosh was there. You please inform. এই লাল কালি আনন্দ
I'm deeply obliged.
Yes. লাল পেন কোথায়? লাল পেন আনন্দ জেল নেই ঠিক আছে না আর লাগবে না এই জন্য কল দ্য লিস্ট
Okay, and I have concluded my submission for the commission of additional commission is concerned, for the dealers are concerned.
বলবে নাকি এটা বলবে নাকি আমাদের রিপ্লাইটা
ওরা বলছি
yes ওটা তো আমাদের এটা হয়ে গেছে Milord,
learned advocate general is supposed to argue.
yes, Milord, I had just spoken to the advocate general. He is on lake, Milord. So, Milord, he has requested to take it up on the 2nd, Milord, at 2. 2nd September at 2.
2nd September, I fix some other matters.
Then 3rd September.
Subject to lordship consideration.
This will be the 6th time, Mr. Basu. He will be making that submission. I am accepting that. He'll be the 6th time. I will be taking that.
So there must have an end.
Milord, what can be done, Milord? This is
can be done.
Milord, this is of course. Nobody denying it. Milord, sometimes, Milord, it happens, Milord.
Sometimes 7th occasion today.
No, this is 6th occasion, subject to correction.
I'm praying before your lordship. In that case, my lord, your lordship pass an interim order. Because matter has been remitted by the division bench by holding that they are not making payment.
No, definitely not. Definitely not. That has been not decided. That has not been decided. I cannot open the case in absence of the advocate general. Lordship kindly takes it up on the 3rd.
Appear in every matter in other courts.
Yes.
Not in this court. I have to protect my.
No, it is not the case that the advocate general is avoiding this court. He has some Milord. He has on lake.
Kindly see the order passed by the division bench 18 July. What is the observation? At page 4. Let it be fixed tomorrow.
But 2nd or the 3rd.
Week after week, I am fixing this.
So only 2nd or the 3rd.
Otherwise, I will
Lordship kindly record that if advocate general does not come on that day, we shall pray for an interim order. On the one hand, crores of money.
This cannot be decided in that event because he has to show the EPOS machine has been installed on his Milord, the shop. Otherwise, what interim order he will be seeking?
So if you are aware about the matter,
No,
you can argue.
Millet, I can argue, but the desire of the client, I have to give them the importance. The desire of the client is that the Advocate General would be Millet making the submission, because this is somehow relate to the Millet the policy decision of the government. So Millet, the best part is that Millet, the Advocate General, let him come on the 2nd or the 3rd as per the convenience of Lordship Millet.
On that day again, adjournment
I cannot.
Kindly give it the first priority item number 1 on 2 p.m. Kindly give priority, some priority item number 1,
As item number
1.
1st of September.
Well, first, no, kindly take it on the 2nd. He has initially requested me 1st, 2nd, or the 3rd. Then he said, no, not the 1st, 2nd, or the 3rd.
Make it item number 1. Otherwise,
2 তারিখ
আমার আছে অ্যাডভোকেট আরে আমি দাদা বুঝে
I have fixed some matters for Advocate General another date. What is the date?
No. Item number 7
is also Advocate General. So both this matter can be take up on that day.
7, I am not there.
Today's matter.
Yes,
I am not there in the 7.
Item number 7, so far the vacancy notice is concerned.
Sudip Sarkar.
Yes, 2024 vacancy. There is a request of the division bench to take up by your lordship at the earliest date. An affidavit has been exchanged. Mandatory direction has been given by the division bench in that matter. 7 days and 3 days that has been concluded. And at least 20 to 25 matters pending before your lordship on the same issue.
Learned Advocate General was engaged to argue this matter on behalf of the state. An accommodation is sought for on behalf of the state authority on the ground that the Learned Advocate General is engaged in another court. Mr. Sahara raised strong objection and submits that at least 6 times the matter was adjourned due to non-appearance of Learned Advocate, non-availability of Learned Advocate General. Full stop. Mr. Shuman Sengupta, Learned Counsel appearing on behalf of the state, submits that Learned Advocate General will be available on 3rd of June 2025 to argue this matter, and he requested this court to fix the matter on that day. Considering the submission of the parties, it appears that this matter has been adjourned for quite few days. For few days on the same ground. Concerning the same, the matter be peremptorily fixed on 3rd of September 2025 at 2 p.m. For argument on behalf of the Learned Advocate General.
In the top, Lordship is fixing it at the top.
2 p.m.
2 p.m.
2 p.m. করেছি তো?
At item number 1, my lord. Otherwise, again, we are suffering, my lord. Can it be, my lord, item number 1?
Several matters are fixed. There are 4 matters fixed on that day. Already.
We will try all. Blackmail will come over here.
The whole matter, kindly consider. Otherwise, my lord, before Puja, it cannot be concluded. Give some priority, my lord. Since we are suffering for last 6 months.
On top.
It's a repetition of 2024.
Okay.
Item 7 may also be fixed because Advocate General is not coming.
এটা উৎস দাঁড়াচ্ছিল নাকি কি একটা দাঁড়াচ্ছিল শীর্ষণ দাঁড়াচ্ছিল নাকি এটাতে?
Article 7 may pass the same order because this has been adjourned also time and again.
Same order, 7.
I'll get close.
Call the matters.
I'm for the petitioner.
Millet 5 can be takes it up on the day after tomorrow.
No, in this matter, argument concluded.
No, we are taking the preliminary objections of the maintainability of the same 6.
There are two
petitions. Yes.
Matter has already been concluded.
Okay. Okay.
I will be yes.
This matter concluded.
Yes.
That is
Fine,
item
day
number
after
5. And you are in item number 6.
6. Me and Mr.
5.
We are on the 5. Sorry, I'm on the 5. 6 of the Mr. Sinha's matter. 6.
That was concluded.
5 here.
Day after tomorrow, 2 p.m.
At any time, your lordship may fix it up at the 12. I will come up and make the submission. Or 10:30 করে দিবি?
After tomorrow 12:30, another matter has been
On the 10:30 also, Millet, I have no problem.
2 p.m. 2 p.m.
2 p.m.
5 and 6, both 2 p.m. Day after tomorrow.
তোরটা কি চলবে?
আমারটা ধরে গেলে চলবে যদি কিশোর বাবু করে তোর কত কিশোর বাবু সাবমিশন আমি তো হবে না।
তুই ফাইল আজকে থাকবে 5-6
হ্যাঁ
2 p.m. Day after tomorrow. ঠিক আছে এমনি ফিক্স। এমনি নট call the list.
In 8 minute, I am for the private respondents. But I may be
But I
permitted
appear
to
for the state respondent.
file my replies. Affidavit in opposition, actually. Copy has been served and they have given me the copy of the reply.
Who is for the petitioner? Mr. Pathasarathi Bhattacharya. Who is for the petition?
Yes.
From the record, I find Shirin Hossain.
Pathasarathi Bhattacharya, Sufi Kalam.
Pathasarathi Bhattacharya was leading him. On the previous day, Mr. Bhattacharya appeared.
Yes.
More senior is it?
No, petitioner is senior.
So what is the matter? A report in the form of affidavit by the respondent has placed.
Respondent state has also been, it has also been filed. Copy has been given.
Filed the affidavit in opposition.
Yes, yes.
Yes, I have given the filed it today and copy has already been served. They have given me a copy of the reply. It is not a dispute actually regarding the dealership of a ration shop. The petitioner original dealer died. There was a dispute between the family members for getting the compassionate appointment. They are challenging. Actually, I am for the second wife and Mr. Bhattacharya is appearing for the my stepson.
Well, the dispute is subject to correction. Well, the original dealer had 2 wives. First wife died. The second wife is applied.
Mr. Bhattacharya appears.
So,
I could not come in time.
petitioner है तो वो petitioner है पर तो petitioner है तो now मतलब the shortly मतलब the gist of the matter is that
have you served the affidavit in opposition?
Yes, yes, they have given the reply.
Affidavit. Respondent number 5.
Just 1 second.
The reply পেয়ে গেছি।
reply দিয়ে দিয়েছে
হ্যাঁ।
You find an affidavit in exception and affidavit in opposition on behalf of respondent number 3.
5.
That is there.
So whether you have used reply like that,
Yes, I have been served with a copy.
Just say one thing.
report and reply against the report of the state or
Even my
exception.
senior who is appearing, I do not find it. That is the reason I am being put to a very disadvantageous position.
That is always there. You have
Whatever
to
I
bear with
see
it.
in the record, there are report in the form of affidavit
By
and
the
affidavit
state,
in opposition by the respondent of 5. But no reply on your part. No reply or exception. Reply or exception, nothing is there.
That should be given. If he has not given, then Miller, I just only say that after reading the brief, it came to my mind that the only point which is required to be gone into insofar as the present writ petition is that whether in view of the Mohammedan law, whether the personal law prevails over the West Bengal Public Distribution System Maintenance and Control Order 2030. This is the only point, subject to correction of my notes.
Not on this point also, I have my submission.
I have got judgments. Now, and can I say one thing? Would you Lordship Miller take it up?
No, you use the reply. You use reply. You complete the pleading first.
That's, that should be done.
Yes, they have taken this point also in their affidavit.
Tomorrow, my lord, I have some
It is-
difficulty.
no, no,
Tomorrow it is not possible.
reply আমি জানিও না রিপ্লাই দিয়েছে কিনা একটা ব্রিফ নোটিশ দিয়েছে
কি করা যাবে?
Okay,
তোমার
I
আমি
understand.
জুনিয়র তোমার।
So when next
আপনার মতো এতটা ভালো ইন্ডিয়ানই না আমি কি করে বলবো
okay, affidavit in opposition on behalf of the writ, on behalf of the respondent number 5 be taken on record. Full stop. Petitioner is at leave to use a reply against the affidavit in opposition filed by the respondent number 5 as well as
already mirrored
if not already. No, it has not filed yet.
yes I am just saying that maybe that he had prepared but has not even
Placed on record. Yes.
that's the reason that is the difference.
It has not come to court's record.
Yes.
কোর্টের রেকর্ডে আসেনি।
As well as exception against the report filed by the state within 2 weeks.
Yes, I am grateful to my lord.
Let the matter appear in the list on 16th of September.
তোমরা এত ব্যস্ত থাকতে মামলা নাও কেন আর আমাকে
16th of September. No.
আমি নিজে এত ব্যস্ত আমি
16th of September.
16th of September.
এখন দিচ্ছি হ্যাঁ রিপ্লাই দিচ্ছি কোথায় দিয়েছিস কোর্টের রেকর্ডে নেই I have already submitted reply my file file
Not filed.
দেখ এই তো আমাকে যে ব্রিফ দিয়েছিস আমি হাতে তো এই তো নিচ্ছি সরি
কোর্টে ফাইল হয়নি, কোর্টে ফাইল হয়নি।
You have placed senior in a awkward position.
sorry my lord exception it is exception
Yes, it is ready but not filed.
that is right my lord that I am not in a position to say anything sorry my lord it is ready I am fine তো সবাইকে কপিটা দিই হ্যাঁ কপি দেওয়া হয়েছে কপি দেওয়া
আমি কোনো কপি পাইনি,
চেক কপি দিয়েছি
কোনো কিছু পাইনি।
কপি দিয়েছি তো
আমি কোনো কপি পাইনি।
দাও দাও
কপি দিয়েছি
তুমি কপি দিয়েছো? ও হ্যাঁ, এক্সেপশনাল কপিটা পাওয়া গেছে। sorry।
Yes, Raya Saab. This is
affidavit in reply by the petitioner against respondent number 1 to 4
yes
and against respondent number 5 against respondent number 5
I against কি কিছু দিয়েছি yes already but I have already given my lord
1 to 4
এটা 1 to 4
পরের দিন দিয়ে দিও রেডি
না না না, দিয়ে দিয়েছি দিয়ে দিয়েছি আমি অলরেডি ফাইল করা হয়নি
একটা কপি দিন না আমি একটু দিয়ে
কোথায় আমার এক্সেপশন কোথায় আমার এক্সেপশনে তো আমাদের রিপোর্ট ফাইল হয়েছে গভর্নমেন্ট
হ্যাঁ ওইটা একটা কপি একটু
গভর্নমেন্ট ইজ সাপোর্টিং ইউ
অপোজিশন
you should give your opposition
দিয়েছি দাদা
এটা কপি পাইনি পেলে ভালো হতো
কবে দেখতো দিতে পারিস না
না আমি কপি দিয়ে দেবো
দাদা রিপ্লাই সার্ভিস করেছি তো দিয়েছি আমি
অরিজিনালটা ফাইল করতে হবে
অরিজিনালটা
কি হচ্ছে এটা কি
Mr. Datta, have you received a copy?
yes
My learned friend also received a copy, my reply.
exception yes
Their reply. Where is
exception
their
to
reply?
exception yes
1 to 4 well, I have been served with a copy but
সেটা 5 Okay. You come on 16th. Okay, okay. You come on 16th. You come on 16th. I fix the matter on 16th. You come with all the reply and exception.
9 8
Call next matter.
02
Same position, my lord.
হ্যাঁ কি নাম জানো
It's a matter of Bengal agency.
Yes, my lord.
Again,
my lord, the
Advocate General is going to start the argument.
on 4 occasions, my lord, matter, my lord, was adjourned, my lord, at the instance, my lord.
allegations are all allegations galore against the landed advocate general he is absent he is absent
3 matters I have fixed.
yes
for
I have heard
consecutive
one
days.
is Sara's matter
Yes.
6 times and your
Okay.
case 4th time
4 times. Ask your advocate general to make his appearance.
Is
Why he's
late
not?
in courtroom number 26.
But every time it's happening to my case, that's, I'm surprising.
On
Why?
No, the issue is that the matter has to be concluded. Otherwise,
Yes, my lord.
by
At
part, it
main
cannot
hearing,
be-
yes, my lord.
whatever may be the.
Because it's subject to convenient of this
I have
lordship
fixed
by
two
the
matters.
kindly
I have fixed 2 matters at 3rd of September. Advocate General's matter, part heard matters.
lordship
Direction.
can keep this matter on that day. Because by any
third matter
yes, yes. Mr. Sahara would be given preference.
That day, if Advocate General starts, I will continue all day. That
Lordship.
is the situation. Whether Advocate General will do that matter on that date, 3 matters, all long matters. This is also a very
Yes,
long
this is also
very long matter.
it requires some
Let's start 3rd.
Yes.
Let's fix on 3rd.
Third.
3rd at 2 p.m. as 3rd matter.
yes.
Yes, as a third matter.
Previous 2 matters for
Deputy
Advocate
Deputy
General is there.
Deputy যদি বলে তাহলে আমাদেরটা প্রথমে থাকবে
ও বাইরের মামলা ঠিক আছে ঠিক আছে
Previous 2 matters already fixed.
হ্যাঁ yes.
স্পেশালি ফিক্স করে
Let it
On
be
all the
specially
matters,
preemptively, my lord. Let it be
ওই যে
specially fixed, my lord.
fixed
Otherwise,
থাকবে।
my lord, it will never be, my lord. Okay.
in this matter, learned Advocate General represents the state to West Bengal
Phone
Essential
number-
Commodity Supply Corporation.
Yes, yes.
কি বললাম বলো?
1, 2, and 3.
Learned Advocate General represents West Bengal Essential Commodity Supply Corporation Limited within bracket respondent number 1 to 3. Full stop. Today is fixed for argument on behalf of Learned Advocate General. An accommodation is sought for on behalf of the Learned Advocate General. Considering the submission, let the matter appear in the list on 3rd of June, 3rd of September 2025 at 2 p.m. as a specially fixed matter as item number 3. As third item. As third item. First 1, 2 দুটো গেছে, এটা third item.
I'm grateful to you.
Yes. 10.
My lord, in item number 10, Mr. Pingal Bhattacharya for the petitioner, my lord. He is on his leg in court number 10 in a continuing matter, my lord. Kindly keep this matter in Wednesday or any day, your lordship.
Now, why it is appearing at 2?
Madam, let me, so first of all, my lord,
Said the 207.
I beg apology, my lord, that it is not a motion matter, as I have written. This is hearing matter, but along with this, 207 should also appear, because it is in respect of the self-same vacancy. So both the matters may be placed any day of your lordship.
No, why it is appearing at 2 p.m.? No affidavit.
No, my lord, affidavit is ready, my lord. Affidavit,
For the state.
it was upon their mentioning, my lord. Petitioner mentioned this matter.
No, the matter is not ready, I think.
No, ready, my
State
lord.
has not used the affidavit.
My lord, affidavits are ready. I'm also filing my state. No, state has also, we have got the copy of the state. But the state is now
Who is for the state?
Amrita Panja Malik. We have got the copy of the state affidavit. That is our report, my lord. We have also got.
For this state, my lordship, Miss Amrita Paja Molek is appearing for this state, my lordship. She went to home due to some personal difficulties, my lordship. I'll be praying for an adjournment, my lordship.
But where is the report?
Next year they will file the report, because this is the first time that it has appeared.
Is there any urgency in this matter? Why it is appearing at 2 p.m.?
The report. My lord, I do not
They
know
have
what
served but not filed in the court.
it is upon their mentioning your lordship had fixed this matter. This is the order of your lordship, my lord, that upon mentioning this matter be appeared on 26th August.
So you want the 207 be add with this?
Let both the matters appear. There is a self-same vacancy. And I shall file my affidavit in opposition to the first matter.
In this matter? Okay. You file it. Have you served the copy?
Yes.
An accommodation is sought for on behalf of the state respondent. It appears that state was directed to submit a report in the form of affidavit. State has prepared a report and it was served upon the parties, but no such report has been placed in the record. Considering the situation, state is directed to submit the report within a weekend. Full stop. Affidavit in opposition filed on behalf of the respondent number 6. Respondent number 6 be taken on record. Reply.
Reply not by 2 weeks, within 6 months.
Petitioner is at leave to use reply stroke exception against the affidavit in opposition and report filed by the state within 2 weekends. Full stop. Next paragraph. Mr. Agarwal, learned senior counsel appearing on behalf of the private respondent, submits that writ petition number WPA
25426.
Two 7 25 WPA 25426 of 2023 pertains to the similar vacancy notification. Mr. Agarwal submits that both the writ petition be taken up together for brevity of decision. Having heard, be taken up together for brevity of decision. Brevity of decision. Let the matter appear in the list.
After Puja vacation, my lord, because in the meantime, my lord, we will file subject to my lord's strength.
Yes. What you want after Puja?
4 weeks. Well, before puja.
Before puja? Before puja, 4 weeks means?
4 weeks time.
All end. Okay. Let the matter appear in the list on 11th of November 2025. Parties are directed to exchange their affidavit in the meantime. अपने लिस्ट को और किसी को next.
Man, I'm giving the list of dates, man.
Oh.
করবি তো রেডি তো
কোন টাইম দেবো শিশাদা করবে তো 5 কোটি 3 10 আছে আমি দেখি
বলে তো মানে মে প্লে
but can it be fixed or edited according to the Mr. Bandyopadhyay on his legs in court number 10?
Mr. Dotto is there.
Mr. Bandyopadhyay.
Oh, Mr. Bandyopadhyay. Sirshano Bandyopadhyay is there.
Today after tomorrow, why not? Tomorrow when is there?
Tomorrow.
Day after tomorrow?
Already fixed 7, 8 matters.
Let it be in queue if it is taken up.
No purpose for fixing this.
Next week, anyway, my lord, I have no.
Next week, first September, I can do that.
First.
That is monthly days of
monthly
September.
This
monthly is fine.
That's
whatever may be. First day of September, I am fixing. Let the matter appear in the list on 1st of September 2025 under the same heading.
Play this. What the hell?
And for the petitioner, in this matter, I have argued the case and they have also concluded their submission. I shall just give the reply.
Yes.
Matter relates to my imposition of fine near about 8 crore against the dealer, not the distributor. Just I'm deep facts, then my the points of law they have already argued. I shall give try to. You kindly come to page 33 of my writ petition. Just I shall at a glance if the petition. Page 33. So this is a show cause notice. Kindly see the date 12th of February 2024. The charges is that, my lord, some cards, furious card has been tagged with me. I have delivered the ration articles. Kindly see charge number 1, 2, 3, 4, 5. First charge, kindly second paragraph, 2 inquiry reports, 2nd November 2023 and 3rd November, second paragraph, at page 33. A inquiry team visited the district on so and so. Kindly see where they have visited.
Page
33. This is a show cause notice.
Yes.
Dated 12th of February 2024. First paragraph, whereas complaint from Shomollo Mia and others was received. First point I have taken, this complaint has never been supplied to us. They have also not denied the same. Second, whereas the inquiring team visited the district, kindly see, on 2nd November 2023 and 3rd November 2020, behind my back, this inquiry has been conducted. I have not been provided any copy of the report. Third paragraph, whereas as per detailed finding, most of the families, no specification, nothing. Most of the families, who are the family members, I have not been given any intimation.
Yes.
Families, the treatment that they did not recognize many deactivated beneficiaries who were then in the family as per inquiry report so and so. This inquiry report has also been not supplied to me. Whereas it is also appears that the cards deactivated through from so and so which families are not aware. details of the families has not been intimated, whereas it appears that unless a cyber received by the so and so, then next one. Whereas from the findings of the physical inquiry, it appears that the so and so ration card regularly. Whereas from the so and so said paper shop has violated so and so, whereas so and so, so and so. So, 3 inquiry I have shown to your lordship from first, second paragraph 2 inquiry, and the further inquiry kindly see my lord. Last but third paragraph, whereas as per another report, have you lordship got my lord, another report of the inquiry, no date, nothing. Then my lord, I submitted my reply denying the entire facts and saying that so far the issuance of ration cards, cancellation of the same, suspension of the same, or deactivation of the same, I have no role to play. I shall rely upon your lordship, my lord, definition clause 2A and 2W, which clarified that entire job is meant for the food officials.
Yes.
Definition clause 2W and 2Y. 2X, sorry, my lord, at page 1.10 of the book. I have already shown to your lordship.
Yes.
Then an hearing has been provided to me, 36 page, first paragraph, Mahakama Niyam AKA, page 36. 323 জন কার্ড হোল্ডার 323 কার্ড হোল্ডার নাম ডিলারকে পড়ে শোনালেন, ডিলার রেশন গ্রাহককে চিনতে পারেন কিনা এবং ডিলারের হাতে সেই লিস্ট দেওয়া হয়। ডিলার কোনো ক্ষেত্রে রেশন গ্রাহককে চিনতে পারলো, 23 জনের মধ্যে কোনো রেশন কার্ডকে চিনতে পারেননি। আপনার প্রদত্ত লিস্টে কোনো ব্যক্তি তাদের পরিবারের লিস্টে অবৈধ কার্ড হোল্ডারদের চিনতে পারছেন এবং তারা সেই সমস্ত গ্রাহকদের রেশন গ্রহণ বলে দাবি করছেন, তারা মিথ্যা বলছে। দিস মাই বোল্ড অ্যান্সার। So whatever allegation has been verbally placed, that is false. None of these family members has ever been allowed to me to cross-examine. This is another point. I have not been intimated who are those family members. Then you will also kindly come to page 38. Show cause issued, reply submitted, hearing has been provided, no decision has been taken. Your lordship knows under the provisions of the control order, 60 days is the mandate. Proceedings has been dropped by elapse of more than 60 days. That provision I shall show to your lordship from the control order, mandatory provision. Now your lordship kindly turn to page 40. Another inquiry has been conducted. On 25th of June 2024, kindly take note of bottom portion, right hand side, average weight obtained by 10% owing. My specific statement in my petition, I have provided laborers, all machineries, weighing machines, that didn't take help of those assistants. 10% owing so and so, kindly take note of my lord, what is the shortage? 49.89 kg, 4 quintal, 8 bags. Your lordship knows that dealer normally keeps my lord more than 60,000 bags. Out of that, only 8 bags. 49 kg means my lord, if I hold my lord 50 kgs. This 5 quintal means my lord 50 kgs bag, 8 bags out of 60 or 70,000 bags. Now kindly come to the next page. Again, calculation has been given, last page, last paragraph, 4.3760 quintal, meaning thereby my lord 8 bags. The next page. Page my lord 43. What is the report? Dated 25th June 2024, 25th June. Everything is all right. Kindly see first table. Displayed. Whether you so and so, yes. Kindly e-post machine, yes. Everything is in form, no allegation. Left hand side, everything has been done. There is no violation or any contradiction so far the control order is concerned. Only bottom portion, again 4.376 quintal, meaning thereby 8 bags. Now your lordship kindly come. The funny thing is that 8 charges has been framed against me. Previously I have shown to your lordship from page 33. Reply has been submitted, opportunity of hearing is provided, no decision has been taken. Yes. Proceedings dropped. Now reviving those all charges, kindly take note of side by side page 33 and my lord page 46. 33 is dated my lord 12th of February, 46 is dated 26th June. This is in respect of the second inquiry. Kindly see, first one same at page 33, second one same, the inquiry report 2nd November and 3rd November, kindly take. Then third paragraph, same charge as per the detailed findings, Fourth one is same, fifth one is same, page 46 and 33, side by side. Borrowing all those charges which has already been dropped after elapse of 60 days, which is the mandate and the control order, that you have to conclude the proceedings.
Yes.
Show cause reply, hearing, no decision, proceedings drop, bringing all those charges, fresh show cause notice. Up to 9, same, then only one new charges has been brought against me. If you will kindly turn from bottom, third paragraph. From bottom, page 46, third, up to before that, all are same charges. Whereas, as per another feedback, have you also got my lord? Page 46, from bottom, third paragraph. Whereas, as per another feedback obtained regarding 269, kindly take note of presently deactivated cards. My lord, kindly take note of the first one, page 33, 36. They have stated 323. The questionnaires. So for the first show cause is concerned, page 36.
Yes.
330, now it is, my lord, 269. And ultimately it will become, my lord, more than 6,000. I shall show to your lordship. Number of presently activated cards, it appears that the concerned family members did not recognize the deactivated cards holders who were listed in the families as per the database report so-and-so and also so-and-so. Whereas the appears that the will be delivered, the committee and offense of the misappropriated chiffoning of a huge quantity. Kindly take note of. The quantity has not been mentioned. Huge quantity. Everything is vague. Then, as per the inquiry report, last paragraph, 4 quintal shortage. Last paragraph. Have a look at my lord. This is the only. In the inquiry, it is only found 4 quintal rice was shortage. Then next paragraph, I have been asked to submit my reply. Again, I have submitted the reply, page 48, by saying that had there been proper measurement by using my lord the weighing machines and levelers instead of eye estimation, there should not have been any shortage, not a single quota. My second point is that I have brought all the officials, my lord, all the levelers, weighing machines, you have not taken help of them. And my third submission, so far my reply is concerned, I don't have any role so far the issuance of ration cards, cancellation of the same, deactivation of the same, suspension of the same. It's the entire prerogative of the food officials, and that will appear from their opposition also. I shall show to your lordship. They have admitted that position. The first paragraph number 1, I have categorically stated what case I have made out. Then last paragraph, if you lordship kindly take note of page 48. I say that I cannot either activate or suspend or transfer any DRC. I have lifted the subsidized food grains according to my tagged ration card holders and not within my knowledge which nation is deactivated. I have no knowledge about the deactivation. These are my submissions. Then kindly turn to my lord, page 53. And kindly, before that, my lord, if you also kindly turn to page 53. Now it is become again to 323. The show cause says at page, my lord, 45, 269. First show cause 323, second show cause 269, then third at the time of hearing 323 again. But need not go through the entire questionnaires. Kindly turn to page 53.
Yes.
Facts have been stated. I am not going through the entire facts. Only repetition of the show cause notice, then last but one paragraph. Whereas under the above circumstances has been established that the dealer has committed an offense of misappropriation of huge quantity, but quantity has not been disclosed, of food grains meant for public distribution against ration card issued from 2015. Can you take note of? In the show cause notice, two proceedings, hearing, never disclosed any charge since 2015. This is the first time in the final order a fresh charge has been brought against me. I am distributing ration articles to the deactivated ration cards from 2015. Only in the punishment order. Now, therefore, in penalty calculation of so and so, it's separate with 3 so 7 crore 85 lakhs. Not a distributor, dealer. In calculation of penalty. The last paragraph kindly read, my lord, therefore a penalty, calculation of penalty tabulated in separate sheet, not supplied to us. And they have admitted in their opposition also. How they have calculated this huge amount, for which period, how many families, nothing has been disclosed. 7 crore, how they have calculated, how many families from which period, nothing has been there. Then next page, I have been directed to deposit the money within certain time. I prefer a statutory appeal, page 55. All points I have been taken. If you have to kindly come to page 56, up to page 68.
Yes.
63. This is a 8 pages appeal, all grounds. I am not going through the grounds of my appeal. Kindly come to page 68. How vindictive I shall show to your lordship the order of the appellate authority. 17 September 2024. Kindly take note of. Did not go through the entire order, repetition of the show cause notice and order of the subdivisional controller. Then kindly turn to page 70. Last but one paragraph. In view of the above, the fine so-and-so calculated so-and-so, dated so-and-so is hereby upheld. As per provisions of paragraph 25 of the West Bengal Public Distribution Control Order, hereby directed to deposit the said amount within 10 days. Kindly take note of. This is the order of 17th September. I have been directed by the appellate authority to deposit the money within 10 days, meaning thereby by 27th of September. Now the licensing authority again rise. Kindly come to the next page. On the very next day, my license has been suspended on the ground that I have not deposited the money. Kindly take note of the date. 17th appellate authority directed me to deposit the amount within 10 days, meaning thereby I have to deposit the money by 27th. On the very next day, subdivisional controller passed an order of suspension. With the observation, I failed to deposit the money. September 2024. Therefore, second paragraph, therefore, considering the gravity of the offense in the interest of the beneficiary of public distribution system, as per clause 24A3 and clause 40A of the West Bengal Control Order 2013, your FPS dealership is hereby put under suspension with immediate effect. The first paragraph says, since I have not deposited the money, despite fact remains, the higher authority, appellate authority, provided me another 10 days time.
Yes.
I came before this honorable court. An interim order has been passed, restraining the respondents from demanding the money, rather the penalty amount. So far my suspension part is concerned, that has not been stayed. The order dated, if I should kindly take note of Justice Right October. The order. I will have to got the order. Justice Right October.
Yes.
So penalty amount has been stayed by the 25th September order, my lord. Justice I. Chattopadhyay.
Yes.
Now, your lordship, kindly take up the opposition filed by the state. This is a voluminous one. It was affirmed by one Gopal Krishna De, affirmed on in the month of December 2024. Date is not there. Have you lordship got Gopal Krishna De?
Yes.
But kindly take up page 30. But none of those documents have ever been supplied to me. I have get access to all those documents which I have annexed in the opposition from the opposition. First time. But kindly come to page 30. First line, a complaint from Shomalom Miha. I have already submitted before your lordship. Till today, I have no knowledge about such complaint. Then kindly come to the table. Now it will be, kindly see, 323, 269. Now you will also kindly take note. Finding physical inquiry. The team visited the village of so-and-so Gopalpur on 2nd November 2023. This report has never been handed over to me. I have submitted before your lordship. Village has been visited in my absence. I have not been given any opportunity to cross-examine any of the consumers. It is a settled principle that if any complaint is lodged, a person gives some evidence, I should be given an opportunity to submit my reply, or I should be handed over the copy of the complaint and an opportunity to cross-examine or examine the person concerned who is lodging the complaint.
Yes.
On 2nd September, also met with the inhabitants in the also then my lord kindly current DRC position of the fair price shop dealer. Left hand side FPS name so total card my lord 5826. Have you also got? Now bottom portion, second line. This is very important. The FPS has near 2,000 beneficiaries in September 2021. Since then, it had been reduced to 6,000. December 2023. Observation of Department so. Due to deactivation. There is no whisper of 2015. Their cases in so far the first shock is not 323. Second inquiry 259. Second shock again 323 families. Now 6,000 ration cards from 2021, not even from 2015. And this document has never been supplied to me. Now, your lordship, kindly turn the page. At page, my lord, what case I sought to made out, my lord, kindly come to my lord, page 34. They have admitted that position. Page 34. This is a part and parcel of the opposition and this bunch of documents.
Yes.
Well, I'm reading from first, second, third, fourth paragraph. Sentence starts, Arts Trial Area.
Yes.
Arts Trial Area Inspector, Kaliachok, Roman 3, Kaliachok 3, Mohammed so-and-so, Nobin Kumar Wal, Data Entry Officer. On being asked about the questionable increase in beneficiary count and subsequent increase in the allocation of food grains through fair price of Astapul petitioner before lordship, the inspector specified that due to huge work, kindly take note of work pressure, he could not tally the advice list with the older ones. On being asked about the process of from receipt and entry in the block of his. He replied that in his presence, he used to receive the form, otherwise from the DRO, used to receive the form. Sometimes another person, Injamunul Haq, who, according to the inspector, is casual staff of the BDO office, also used to receive from inspector, used to verify 10% of the receipt forms. Then, according to DEO, as he was in charge of 2 blocks, all the forms were not entered by him. Rest of the forms were entered by the temporary DEO. However, the present inspector has changed this process, and now all the forms of so-and-so is permanent by DEO only. Then, overall findings of the team. According to the sample survey of the inquiry team, it appears that many cards were created through from 4 about which actual families were not aware. It is also obvious to the team that these families never received their physical cards as well as the allotment of food grains. It may be noted that the cards were distributing through Panchayat till July 2018. From the second half of 2018 till December 2019, cards were utilized distributed through inspecting officer. From the inquiry, it can be referred that the cards counts were increased in benefit of the fair price shop dealer financially and could not have been possible without the connivance of the block food officials. The firm decision is that at my influence, these officials have done. Not a single show cause, not a proceedings against any of the officials. They have admitted, I have no role to play. There are shortage of staff, temporary staff, does some jobs, 10% verification. What is my fault? If the cards is tagged with me, it is my duty to deliver the ration articles on production of the ration cards. If I don't do this is an offense. Kindly come to next page. 25th June 2024. As per your verbal order, we the undersigned officials conducted an inquiry from 24th June 2024 to 25th June 2025. This 1 day, 2 days. In the cluster means Memar dealer, Astapul Hub, Fair Price Shop dealer, so and so, and met with 35 families. Only 35 families. Randomly. 35 family randomly. During this period, we gathered feedback from the cardholders associated with the concerned dealer. So randomly 35 dealers deactivated 6,000 cards in the year 2022. Charged from 2015, I am siphoning the ration articles. No documents, no show cause, no complaint has been served to me. And this calculation sheet, which they have annexed their opposition, I have been only given, I have the access, kindly take my last page of the opposition. How and which manner, no prudent man can understand how they have calculated from 2015. Nothing has been specified. This is a calculation sheet. Only in their opposition they have annexed it, and I get access to this document. How pure, what manner they have calculated it, at least I could not understand from this document.
Calculation of economic cost.
3 times. That's what the control order says.
Yes.
But the period and person and the quantity, nothing is clear. And economic cost, kindly take note of my lord, the last annexure. Kindly see the last table, last line of the after the table.
Yes.
From the period May 2021, taken 2022, 2023, 2022 at the dealer had been high manual of transfer 2023. And penalty has been calculated from 2015. There is no whisper about 2015 in the entire calculation sheet. They says 22 to 23.
Okay.
But they sought to make a case that so far the quantum of shortfall is concerned, that is not under challenge. But we have made out a case for violation of principle of natural justice. We have made out a case for not providing us copy of the complaint, copy of the reports. Before my lord, final order passed, we have no knowledge about that charges from 2015. And the vindictiveness and the biasness will be appeared that the higher authority is saying you may deposit the money till 27th. And on 17th, 18th, suspension order. Now we have relied on 3 judgments. Just I am giving, your lordship has already gone through the same. The first judgment, Justice Somapti Chatterjee, as his ladyship was. Can you take up my lord? This is. Already relied on. 2016 SCC online that I have handed over to your lordship. Messrs. A Traders. 2016 SCC online Calcutta 1247. The first judgment we have placed before lordship. Just I shall remind your lordship the paragraph. 100% women. 2016 SCC online Calcutta 1247. The cost title is Messrs. A Traders.
Yes.
Well, paragraph 22 we have relied on onwards.
Paragraph 20 you have relied.
Yes, 22 onwards. It says without 100% women, it cannot be determined what is the loss or what is the excess or shortage.
Yes.
Because this is a statutory provision. Admittedly, randomly 10% women has been done. Despite fact remains, we provided all women machineries, measurements, and laborers. They have not denied the same also. I have already shown to your lordship on last occasion from my writ petition. There is a specific statement that has not been denied in the opposition. Paragraph 22, 23, 24.
Yes.
The next judgment we have placed before, and none of the judgments I have placed that has been sought to be distinguished even. They have not said anything so far this judgment are concerned. And then, my lord, your lordship judgment we have relied on Vaidyanath Pal. Paragraph 18 and 19. Relying on 2 judgments of the Honorable Supreme Court at paragraph 18.
Yes.
The paragraph 19 is the penalty made paragraph at page 5. It is not out of place to mention herein that petitioner being MR dealer is due to bound to provide the ration articles in a family having a particular number of beneficiaries. The petitioner may have the knowledge regarding the correct number of family members or that family, then also the cannot enter in the holder of ration card to distribute ration articles. It appeals to the post machine. Then, paragraph 20, respondent authority has proceeded arbitrarily in imposing the punishment to the petitioner. A petitioner cannot be held liable, then minor cost and set aside. And paragraph, my lord, in this judgment, paragraph 16, 17, and 18, your lordship has dealt with the facts, the identical facts. What is the duty of the dealer? The moment a card is being placed before the dealer, it is the duty of the dealer to deliver the article without raising any query. I cannot. When you are deactivating, when you are issuing, when you are suspending, when you are terminating the ration cards, I don't have any knowledge. Unless it is deactivated and intimated to me, I am bound to deliver the ration articles.
Yes.
And we have also placed before your lordship Mahinda Singh Gill by saying that they sought to make out a case in their opposition, which they cannot. It is a settled principle of law. If any impugned order is issued, a show cause notice is issued, the reason should be disclosed therein. By way of filing an opposition or affidavit, you cannot make out a case.
1978.
My lord.
On SCC 40.
My lord.
Para 8.
Mahinda Singh Gill. And they have delayed, my lord, only one judgment. Well, natural justice violation we have also relied upon. Kindly take note of, my lord.
BC Chaturvedi, 1996 SCC.
My lord. Paragraph, my lord, 70. Violation of principle of natural justice. This is a glaring instance of violation of principle of natural justice. And they have relied on judgment, only one judgment, that is, my lord, reported in 1995, volume 6, Supreme Court cases, page 749. But this is, my lord, BC Chaturvedi, Union of India. I am thankful to my learned friend. I should have placed this judgment before your lordship at the time.
Paragraph 12.
Yes, kindly come to paragraph 12. And very cleverly, my learned friend has read out, my lord, only the first portion of the paragraph 12. I shall go through the entire paragraph. Judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessary, correct in the eye of the court. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is concerned to determine whether the inquiry was held by a competent officer or, kindly take note of, whether rules of natural justice are complied with. Well, this is our case. Principle of rule of natural justice has not been followed. Then, whether the finding or conclusions are based on some evidence, the authority entrusted with the power to hold inquiry has jurisdiction, power and authority to reach a finding of fact or conclusion. But that finding must be based on some evidence. This is no evidence. I have not been provided any documents. I have not been given any opportunity to cross-examine any of the family members. I have not been given the details of the families. 326 families, 259, then 6,000 ration cards. Meaning thereby more than 1,000 families. Now, my lord, I am continuing. When the authority accepts the evidence and conclusion receives support thereof, the disciplinary authority is entitled to hold that the delinquent officer is guilty of the charge. The court tribunal, in its power of judicial review, does not act as appellate authority to appreciate the evidence and to arrive at its own independent findings of the evidence. Then, the court tribunal may interfere where the authority held the proceedings against the delinquent.
Yes.
I'm reading from bottom 8 lines, paragraph 12. The sentence starts, the court tribunal. The court tribunal may interfere where the authority held the proceedings against the delinquent officer in a manner inconsistent with the rules of natural justice or in violation of statutory rules prescribed in the mode of inquiry, or where the conclusion of findings reached by the disciplinary authority is based on the no evidence. If the conclusion or finding be such as no reasonable person would have ever reached, the court tribunal may interfere with the conclusion or the finding and mold the relief so as to make it appropriate to the facts of the same. Well, this is my case. Again, I am thankful for my learned friend. My specific case is that, my lord, the punishment which has been imposed, it is disproportionate. Shockingly disproportionate. For 250 families from 2021 to 2022, it maximum maybe 10,000 or 20,000. They reached to a conclusion that from 2015, I have delivered ration articles to deactivated cards. There is no charge at any point of time. Principle of violation of natural justice, copy of the complaint, not a single report. I have shown to your lordship 4 inquiry has been conducted. My fourth point is that, my lord, 10% women. despite provide all equipments.
Yes.
Only 10% women has been taken. And what is the only charge against me? 4 quintal shortage. This is the allegation. An ultimate penalty on the basis of a vague calculation. And the bias of vindictiveness will be proved from the order of suspension. Higher authority, make payment 28, subdivisional controller, no, suspension. These are my cases. How much are you? I'm not in a position to run my business. On last occasion, I have also placed a judgment that says suspension order cannot be continued more than 60 days. Division bench.
Yes.
Mohammad Yasin. In this case, my lord, possibly, my lord, we are on 6 months. Mohammad Yasin, I have already placed before your lordship. This is reported in 2006 Supreme Court cases online, page 200. It is also reported in other local judgments. Mohammad Yasin. It says, my lord, proceedings may be continued for more than 60 days, but suspension should go because this takes away the livelihood of the dealer or the distributor. In this case, 6 months I am under suspension. We are about 1 year. My lord, almost. These are my submissions.
Argument on behalf of the petitioner on reply concluded. Let the matter made CAB.
I'm getting much of it.
CAB. Pardon.
But I am for the petitioner, but Onmita Pajamoli is appealing for the state. He requested me to refer not today. She has left.
Not today.
Can it be placed that to be mentioned matter tomorrow? Because no, can it be mention matter? Because tomorrow your lordship will take up the mention matter.
Yes.
Some urgency is there. Can it be placed as mention matter?
How many mention matter tomorrow?
Not number of matters possibly.
$35.
It may be 36. Take a try.
Okay, mention matter.
I'm getting much of it.
Thank you.
80.
Late by me, no, Lord. I'm
Yes.
praying for not today, Lord.
Not today. Why? Not ready.
Not ready, Your Lordship. Kindly make it not ready. Item number 82 and 83, Lordship.
81,
82 and 83.
82 and 83, not today.
Grateful Lordship.
84, I'm appearing for the petitioner. I'm appearing for the petitioner, my lord.
Call the list.
I'm for the petitioner, my lord. I'm praying for a not today. My senior is engaged in another court.
Not today. All not today, very well. Not today. Not this week. Next. Not this week.
86, my lord, I am for the state. My lord, will kindly. My lord, this writ petition, my lord, has been, the petitioner is not there. My lord, after being unsuccessful, my lord, the writ petitioner has come up and challenged. My lord, lordship knows, my lord, in paragraph, kindly takes, my lord, page 17 of the writ petition for a moment. Page 24, I stand corrected.
Yes.
My lord, page 24, clause number 11, Roman 5. Kindly sees, my lord, the terms of the vacancy notice. The licensing authority or government in food and supplies department reserves the right to reject any application or cancel the vacancy at any stage of the proceeding of the applications without assigning any reason thereof and will not entertain any correspondence on this score. Now, my lord, so far as, my lord, the maintainability, my lord, this point is very clear. My lord, the government, my lord, reserves the right to reject according to the vacancy notice under which, my lord, the petitioner had, my lord, applied. And my lord, if I am to even accept, my lord, if this, after being unsuccessful, my lord, one cannot turn around and challenge. Had it been the case that before even participating in this whole process of selection, the petitioner had approached this honorable court challenging that the term is not fair, that would have been a different scenario. But today, after you participate and you become unsuccessful, you have come before this honorable court. And my lord, this is, my lord, on instruction I am saying, so far as, my lord, the merit of the case is concerned, the person who is selected, my lord, he has secured a score of 79, 73, whereas the petitioner has secured a score of only 09. So, my lord, in my respectful submission, my lord, this writ petition is, my lord, not maintainable, neither it is entertainable.
Okay. None appears on behalf of the petitioner on call. State is represented by Learned Counsel, Mr. Namrana Shomudi. Learned Counsel for the state submits that the instant writ petition is not maintainable. The petitioner is an unsuccessful candidate, having secured very less marks than the successful candidate. However, considering the entire circumstances, the petitioner is not turning up. Accordingly, the petitioner may have lost interest to proceed with this matter further. Under above circumstances, the instant writ petition is dismissed for default.
Very well. I am grateful to you, Lord.
And for the petitioner, your lordship, the affidavit of service has been served.
Yes.
So in this case, sir, your lordship, the petitioner applied for one APS license. The respondent number 8 issued that vacancy in the year of 2024 on 15th of May. And based on that, one inspection was conducted by the respondent number 8. But even after that, no such result was published by the respondent number 8 in that portal. And when respondent number 9 got that particular license and that news and that information was received by the petitioner only after visiting the very subdivisional controller. And after that, the respondent number 9 got the license without any particular information of that particular application. Now, the petitioner, when went to the office and asked for the particular application and the particulars, he was denied. Not only that, the particular petitioner, when got that particular information from the subdivision controller, they haven't provided any information regarding the procedural applications, procedural requirements that was prescribed by the very vacancy notification. So it was completely violation of the principles of natural justice.
How?
The thing is that,
Have you made any representation?
yes, Your Lordship.
Where is the representation?
Yes, on page number 39, Your Lordship, I made one representation after that employment, after that particular license has been granted. And then they conducted one inquiry based on that representation. They provided one scorecard also. The scorecard mentioned in the page number 53, Your Lordship. The scorecard says the petitioner got nil, that means 0 marks hearing. Whereas in this particular case, the state government had issued one notification in the year of 2021 on 17th August, stated that even a particular
Where is the scorecard?
on page number 53, Your Lordship.
This is the petition of Vaidyanathan party.
I made one application before the authority, and they have made an order by giving one inquiry order, and they also called me for one hearing, wherein I have submitted all the documents there. And after submission of all the documents, they have provided me this order. Whereas in this order, they have given me nil marks. Whereas I have made all the basic criteria as mentioned in the vacancy notification. Now, in page number 36, they made the particulars as in for panchayat area, there should be one 400 square feet area for office purpose. Now, if that particular is available, they should give 2 marks or 5 marks minimum for that particular having that area as per the notification. I would like to submit the notification herein. In that notification, it has been clearly stated, if the godown along with that office is more than 400 square feet, it should be minimum 5 marks. But in this particular case, in the last measurement, they have given only 0 marks. So the participating respondent number 9 got 68 marks. They assigned that particular number only after post application, post procedure of that vacancy procedure. This is complete a violation of that.
Violation. Where is your office?
My office is at the same place of that respondent number 9.
That means you don't have any office, you have only go down.
No, I have that office, Your Lordship. When I have already submitted that thing, but they haven't mentioned. This is the only thing that for I came before the Your Lordship. I have office. I have even in that application, I have mentioned that I have office and go down both the same particular premises along with that. And it is of 400, more than 400 thing. But they haven't assigned any marks also. They haven't mentioned for that also, Your Lordship.
You have your
Office space, and go down, both.
Space 462.
Yes, Your Lordship.
This is the same compartment you have saying that this is the office.
No, sir, no, Your Lordship. Go down and office both are there. And it is also a eligibility criteria.
Not separate.
Yes, sir, separated by one wall, Your Lordship.
Where is the anything?
No, Lordship, by supplementary affidavit, I will submit on the next date, Your Lordship, if you say, sir.
Is there anything? Not by supplementary.
I have submitted before the concerned authority, Your Lordship, that I have that particular go down and office both. And in a single compartment, Your Lordship, as mentioned in that particular vacancy notification, that there can be.
Only single compartment you have?
Yes, yes, Your Lordship.
Then?
I have single, it is an eligibility criteria to meet that particular thing.
Read.
Okay.
Read it.
It must have the space of minimum 300 square feet along with a covered space of 100 square feet adjacent to the godown to be used for office purpose. Yes, Your Lordship, however, if the godown and shop are accommodated in the single compartment, the area should be minimum 400 square feet. However, there is a provision, the same one.
So they have said that you don't have any separate office space.
Yes, Your Lordship.
That's why they have given you less marks.
Not only marks, they haven't assigned any marks to the petitioner. The thing only problem is in page number 54, Your Lordship. The marks got the particular the black area there is completely said that is a nil area. Nil, and the respondent number 9 got 68, Your Lordship. But as per the notification dated 2021, a person who is participated in such vacancy notification, they should be assigned a minimum marks for that.
No,
if there is.
You see that whether you have challenged this.
I have mentioned all this, Your Lordship, in the prayer portion, Your Lordship, the representation and as well as the very way by which the respondent number 9 got that particular appointment for the licensing by the license for the license of the APS dealership.
No, you have not challenged this order.
Your Lordship, this particular I have mentioned in that annexures also, Your Lordship, and the prayer portion I have mentioned for the statutory and mandamus both for the directions of the.
Not that. You have to specific challenge this order. Where is the specific order? Whether you have challenged this? Order dated 25th of June 2025. No, you have not challenged this. This is a government decision by an order of your representation. You have to challenge this.
Your Lordship, when in the process, when I intimated the same thing to the concerned authority, they haven't provided any such information to us. Only after granting the license to the respondent number 9.
They are not duty bound to submit your information.
But Your Lordship, yes, Your Lordship. But sir, in the notification itself, it stated that in that portal, there should be given that.
You have challenged this.
No, Your Lordship, I have mentioned the same, Your Lordship.
Not mentioning. You have to challenge it properly. This is a government order. You have to challenge this if you want to. Otherwise, you have no case.
But Your Lordship, in the same thing, there is another issue is also concerned, Your Lordship. The very way by which they have mentioned the same thing, sir, Your Lordship.
You made a representation.
Yeah, I made a representation.
Replied.
Yes,
you
Your
are
Lordship.
happy with this reply. Then you have to challenge this. This is simple. If you not challenge this, you don't have any case. You don't have any. You have challenged, not challenged this. So you don't have any case.
But on the next day, sir, I will file a supplementary affidavit along with this, Your Lordship.
The affidavit cannot change the
For the documentations, Your Lordship.
Maybe. You file a fresh if you want, otherwise I dispose of this.
Okay, Your Lordship.
What okay?
I will not press it, Your Lordship, and I will file an afresh, Your Lordship.
Let the instant
Please
petition be
give
disposed
liberty, Your Lordship.
by the petitioner. Next.
Please mention the liberty, Your Lordship.
Let the representative disposed of with the liberty to sue afresh on the same cause of action. Next. Not this week. Next.
In this matter, I am appealing for the petition. 89.
Chief, in 88, I was on behalf of the state.
Item number 88.
Yes.
None appears on behalf of the petitioner. None?
Visually, मैं थी तो.
88.
88.
Mrs. Sinha appears on behalf of the state respondent. Let the matter appear in the list on the next week.
Next week.
Under the same heading.
Get a petition.
Next.
May I please your lordship?
Yes.
But this is a peculiar case before your lordship. But this is a case where initially
the petitioner has been taken care of by mother and subsequently he has been treated as just like a stepson. Why I am telling you, Lordship, may I apprise the fact before your Lordship. If your Lordship kindly see this writ petition before your Lordship, in the petitioner's father is actually the license holder of two aspects. That is, one is the kerosene oil, another is relating to the ration dealership. Now, after the fathers who become ill, mother steps into the shoes, mother take over the entire aspect, and mother is looking after this entire because the license has been changed in the name of his mother. Now, she has got two sons, one petitioner before your Lordship, another son who has been made party as a respondent, who has created trouble before. Why I am telling you. Now, on that basis, this mother all on a sudden again fall ill, and he made an application that she could not continue with the business. So she shows her desire to allot the license pertaining to kerosene in the name of the petitioner and pertaining to the public work, that is the rations, in the name of the private respondent. These are the two sons. Same day this application has been made. Now, Lordship, kindly turn to page 15 of the writ petition.
1.5. Yes.
This is the application. May I place it before Lordship?
Then
This
what
is the
happened thereafter?
This application has been filed where he has said that due to her ill health, she could not continue, and she had got no objections if this kerosene dealership is granted in the name of the petitioner. She had made two applications, one application relating to the kerosene, another application relating to the ration. Now, subsequently, kindly come to page 16. This is the application made by the writ petitioner. Because this application meant, and he said that he has got no objection. আমার নিকট আমার বিনীত নিবেদন এই যে আমি শ্রী সুপ্রভাত মণ্ডল, পিতা নিরঞ্জন মণ্ডল, গ্রাম বিজয়কোনা, পোস্ট অফিস এত হেলার হুগলি বাসিন্দা হইতেছি। আমার মতো শ্রীমত বিভারানী মণ্ডল এর নামে এসকে অয়েল রেকর্ড শপ আছে, তাহার নতুন লাইসেন্স নাম্বার সাচ অ্যান্ড সাচ, পুরাতন লাইসেন্স নাম্বার সাচ অ্যান্ড সাচ। উপরোক্ত এসকে অয়েল রেশন শপ লাইসটি আমার মাতা আমার নামে পরিবর্তন করিয়া দিতে ইচ্ছুক প্রকাশ করিয়াছে। এত কথা আপনাকে জানাইতেছি যে এই সব অয়েল লাইসেন্স আমার নামে পরিবর্তন হইলে এবং পরিচালনা করিতে আমার কোনো আপত্তি থাকিবে না। আমি this is the he accepted that. So first one is that the application made by the mother, and on that pretext that no objection has been granted by the petitioner. Now, Lordship will kindly see this. Thereafter, in page 25, medical report has been granted by the petitioner. Page 25. Page 25. Lordship got that medical report? Yes. So on that basis, thereafter, page 37 and 37, affidavit has been made by the mother.
Yes.
36 and 37, this is the affidavit whereby on oath, the mother specified that she has got no objection if this license has been granted in the name of the petitioner. Now, subsequently, Lordship, kindly see the 38 and 39 affidavit given by the petitioner. So the due procedure, what has been due procedure, that has been duly followed. Now, Lordship, next come to page 41, 43, where the legal successor has granted no objections. These are the no objections. Now, all on a sudden, now Lordship, kindly see page 70 to 73. there is an inquiry. Page 70 to 73.
Yes.
This is the inquiry. In this inquiry, where it has been specified that inquiry report is in favor of the petitioner. As per the order, Lordship, in the bottom, Lordship got that. As per order, right, memo number such and such for inquiry to AI, the area inspector submitted, Lordship got that. Lordship, kindly take a note on that. Submitted the inquiry report in favor of Suprabhat Mondal for the license on the medical ground report placed for further cause. So the medical report has also been placed, and after going through that, this application has been kept pending for a long period of time. And interestingly, the application made simultaneously by the mother in favor of the private respondent, another son, that has been taken care of, and their license has been granted in favor of the private respondent. But in spite of the inquiry in the favor of the petitioner, in spite of all medical report, in spite of no objection granted, no step has been taken in favor of the petitioner. Now, subsequently, the petitioner made a right to information. Petitioner made an application before the authority under the Right to Information Act. Lordship, kindly come to page 74.
Yes.
Here, this is the application. May I place it, Lordship? Thus, this is the application, and on that basis, and reply has been granted, reply has been given, page 78. This is a very interesting and very, I will say, rather very important aspect in this matter. With reference to the above, this is to inform you that the present license, this is to inform you that at present Vivarani Mondal applied to transfer it on medical ground in favor of her youngest daughter-in-law. Lordship, in one hand, the mother has granted permission on oath. It has been specified that this license is to be granted in favor of the petitioner, and the youngest daughter-in-law, who is the youngest daughter-in-law? May I clarify, that is the son in whose favor that license has been granted pertaining to ration, that his wife should be granted this license. The daughter Srimati Momota Mondal, and this case is under process. Moreover, this is to inform you that the Vivarani Mondal applied for cancellation of transfer of her SQL in favor of Supra, and after submission of a reply against some clarification of this office, previous application of SQL transfer on medical ground in favor of Supra, they are hereby rejected. Now, this is the most vague ground, I will rather say, because in 2016, this application has been made. It has been kept pending for a long time. In the meantime, this, that is the petitioner's, that is the brother who has been granted the permission for carrying out the ration dealership work, without assigning reason within this due time, they sat tight over this matter, and all on a sudden they said that since it has been made that she has not, very interestingly, now all on a sudden the mother said that now I have become fit, now I am ready to carry out this business. Again the mother becomes ill and said, no, I am now becoming ill, now my daughter-in-law will carry out the business. But that was rejected. My bone of contention before your lordship, now lordship, kindly turn to page 81. There is a absolutely violation of Article 14. Kindly see, now thereafter, this clarification, this is the letter addressed to this mother, given that with reference to the undersigned, we inform you that you have shown your eagerness to transfer your SK dealership in favor of your lordship, page 81, 79. I stand corrected, lordship, page 79. I'm sorry, lordship.
Yes.
With reference to the above, the undersigned has been informing you that you have shown your eagerness to transfer your SKO dealership business in favor of your son, Suprabhat Mondal. That is the petitioner before your lordship, Suprabhat Mondal.
Proceed.
Due to your physical illness. Accordingly, Form D and other relevant documents are submitted by the applicant Suprabhat Mondal. Even if you have signed, this is very important, NOC regarding engagement of Suprabhat Mondal as SKO dealer in place of you on compassionate ground. But it is really surprising to find that you have recently submitted a prayer stating you are presently not willing to transfer your SKO dealership business in favor of your son, Suprabhat Mondal, because you are now physically fit to carry on your SKO dealership business, making earlier prayer and court paper NOC shown before judicial mastery a farce. Now the following clarification are sought from you regarding the above noted. Why did you not submit medical fitness certificate from competent government house to ascertain the undersigned about your medical fitness to carry on SKO single-handedly? Why do you suddenly change your decision regarding transfer your SKO dealership business? But this is the very interesting aspect. But now, this is the very fishy things and no reply has been granted. Now, my humble submission, why I am pressing before your lordship, why I have come before your lordship. But this is the court of equity. Fraud vitiate everything. Fraud is the anthem regarding all equity principles. Now, when there is a fraud, when there is a violation of Article 14 of the Constitution of India.
That is the fraud.
Fraud is
It's a private dispute between you
this is
and
the
your
private dispute, lordship. Why I am telling you,
what is your grievances against the authority here?
Authority, because authority is sitting tight over this matter from 2016 to 2022.
Must have come before that, before taking the decision.
But
now they have taken already the decision.
Not decision has been taken, but lordship.
Decision on the basis of your application of your mother.
My lordship,
this is purely a private dispute.
No, lordship, kindly appreciate this may be the private dispute,
Then?
but the authority is standing on the way because
it is very impartial. You see, authorities ask for explanation from the erstwhile.
No reply has been. Then let there be direction upon the authority to make an inquiry upon this issue, because this is a very serious issue.
Already taken the point.
But nothing has been done.
Explanation, that is of 2022.
But they should have cancelled the license of the private brother also, because on the same footing.
No. That is not the issue here.
But issue I have already stated in my report.
Purely your dispute, your brother's dispute, your mother dispute.
This is
why the authority.
But lordship, with deepest respect, I humbly submit.
Asking the challenge the authority's action.
The authority's action is authority standing from 2016 to 2022.
Then you must have come before.
But because I was not aware that these things are going under the cover. So we are not aware. When I came to know. Because when I came to know about this aspect, I suddenly made this application.
No, that is purely a dispute of private parties. The authority has taken decision on the point of application of the erstwhile dealer. Why she changed her mind? Why she again tried to incorporate another person to be a license holder? That is only the license.
But let there be an inquiry on that. Let there be an inquiry on that. Because
they have already initiated an inquiry.
Nothing has been done. The letter has been given in 2022. We are in 2025. Lordship, kindly appreciate the situation.
Since then, nothing
has been done. That's why I am come before your lordship. But justice should not only be done, justice should manifestly seen to be done, lordship. My humble submission before your lordship. In one hand, they have very quickly issued a license, and on the other hand, they have kept it pending for a long time without any valid reason. All on a sudden in 2020, and lordship, kindly appreciate, in 2022, mother had made an application. In the interregnum, nothing has been done. Then in one hand, the license has been issued to the brother, but no license has been granted to this petitioner. This is the main crux of the thing. This is the inaction on the part of arbitrary action on the part of the authority. This is the gray area which has not been dealt with. From 2016 to 2022, lordship.
Not so great. Very clear. They have acted according to the wish of the erstwhile licensee. I can understand your contention if they say tight, but the authority concerned has taken the steps.
Yes, nothing.
Asking the person, that is your mother, why she changed the decision.
Nothing has been done. From 2022, today we are standing in after 3 years. Nothing has been done. And so the license should be withheld of that private respondent also. But there is the disparity. Lordship, kindly appreciate.
No disparity. Why are you saying so
But
disparity?
I am telling you why disparity on the same time.
Now you are challenging your brother's action. Your private dispute you want to contour.
No, I have challenged
Yes,
the
it is
I
a
have
private
challenged
dispute.
I have challenged the government.
Dispute between your brother and you and your mother.
But there is no question of dispute. I have not made any application because the thing is from 2022 onwards.
Very
No
well, I'm
steps have been
asking for
taken.
filing a report
Lordship.
by the state.
Thank you.
Please take down. Mother of the petitioner, SMT Vivarani Mondol, was running a FPS license as well as kerosene oil license under the government of West Bengal. Under the subdivisional controller concern, government of West Bengal. During the continuation of such license, such licensee applied for transfer the license of SK Oil in the name of the petitioner and transferred the license of FPS in the name of another brother of the petitioner in the year 2016. In terms of the on the ground of medical incapacitation. In terms of the application of erstwhile licensee, the petitioner has taken out all relevant documents, affidavits, pro forma applications, and fees so that the license can be transferred in the name of the license of SK oil, kerosene oil may be transferred in the name of the petitioner. The concerned authority has also accepted the medical certificate and conducted a inquiry regarding transfer of such license. The inquiry report was also placed on record. Peruse the inquiry report. Since then, it is the case of the petitioner. Since then, it is the case of the petitioner that the authority concerned sat tight. Consequently, the petitioner filed an application under Right to Information Act seeking some information regarding the fate of the application of the petitioner. The authority concerned has replied the said RTI, and it has been intimated in the reply as follows. Page 78. Stop. Learned counsel for the petitioner submits that the authority concerned is hand in glove with the private respondent and private respondent full stop. Though the license of FPS was duly transferred in the name of private respondent, but the petitioner who has complied with all formalities according to the control order, his license was kept pending since considerable period. Now, by stating some undue reasons, the license, the prayer for transfer of license of SK Oil in favor of the petitioner was turned down. He further submits that the authority concerned, by issuance of memo dated 15/7/2022, sought for 15/7/2022, sought for a clarification regarding unwillingness of transfer of SK Oil dealership business in the name of petitioner due to her physical incapacitation. Full stop. Since then, though the authority concerned has has issued the memo of clarification, but the petitioner is unaware about the fate of the clarification. It is the contention of the learned counsel for the petitioner that though the petitioner has tried to take information about the said proceeding, but he is in dark. Hence this writ petition. Having heard the learned counsel for the petitioner, though it appears that the transfer of license in favor of the petitioner regarding SKOL dealership was cancelled due to the change of mind of erstwhile dealer Srimati.
My lordship, it's not change of mind. She becomes fit, not change of mind. She at first stage she shows that she is ill. Subsequently, she says she becomes fit. Again, she said that she becomes ill. Let it be transferred in the name of
the change of mind.
But
Already all change
ill,
of mind. is there.
The lordship. Change of mind means she is fit and now she is ill.
No, it is the rule that due to incapacitation,
Yes.
you can transfer a license.
Incapacitation.
But if you become again fit, the transfer license can be again transferred.
Again transferred. Again she become incapacitated and she said
that decision has not yet materialized.
Yes.
Okay, full stop হয়েছে কি বললাম?
Cancel করে দিচ্ছে।
Vivarani Mondol, full stop. However, it appears that full stop করো. Affidavit of service filed on behalf of the petitioner be taken on record.
But we have already served to the private respondent also.
Despite service, none appears on behalf of the respondent's authorities or private respondent. Full stop. Considering the situation, I think it necessary to call for a report from the state authority regarding the proceeding initiated by them, asking clarification regarding unwillingness to transfer SKO dealership license in favor of the petition. Full stop. Let the report be filed within 3 weeks from date. Reply if any by the petitioner within 2 weeks thereafter. Let the matter appear in the list in the first week of November 2025.
I'm deeply obliged.
Okay.